Are we live? We are live. All right, good morning, committee. We are back for day 2 of the Blockchain Select Committee. We've got a good half-day agenda. Thanks for everybody's hard work yesterday. Let's take roll call and then get rolling.
Good morning. Good morning, Mr. Chairman. This is roll call for the Select Committee on Blockchain for November 21st. Senator Ellis.
Excused.
Senator Furphy.
Here.
Senator Nethercott. Here. Representative Andrew.
Here.
Representative Singh.
Here.
Representative Yin.
Here.
Mr. Kaufman.
Here.
Mr. Pope.
Here.
Mr. Rebel.
Excused.
Co-Chairman Western.
Here.
Chairman Rothfuss.
Here.
You have a quorum, Mr. Chairman.
Excellent. Any comments before we get started and go to the first bill? Mr. Chairman?
Mr. Co-Chairman, I think it was a long but productive day, a little spice in there, but on the balance, I think this committee did a really good job of really sussing out the issues, and I'm excited for us to keep that momentum going.
Absolutely. All right, with that, let's get started on our artificial intelligence governance discussion. And a little update from the working group, but that'll probably get us quickly to our bill draft 24 LSO 236. So on that working group, we did have some discussion about broader topics of things that we might want to contemplate in the future, but the only thing that really has come out of clear need for legislation for this interim is addressing the deep fakes, which is what we have in the bill draft related to synthetic media. I think everyone's seen an earlier draft of that, but the draft has been reworked and is hopefully in pretty good shape. So, Mr. Hopkinson, if you'll join us and walk us through the draft.
Thank you, Mr. Chairman. David Hopkinson with the Legislative Service Office, walking through 24 LSO 236, unlawful dissemination of misleading synthetic media, working draft 0.6. This bill has had a fair amount of tweaks from the previous version that the committee saw, so I'm going to walk through those and really kind of emphasize some of, at least, there's a lot of, I think, important policy and important means that this bill does. So I'm going to be a little more in depth than I might otherwise be. But the first big definition that is really key for this bill is on page 2, paragraph 2, synthetic media. And that has been changed from what the committee looked at last time. But that means an image, audio record, or video record of a natural person's appearance, speech, or conduct that has been intentionally manipulated or generated with the use of generative adversarial network techniques or other digital technology in a manner to create a realistic but false image, audio, or video, or other representation that to a reasonable person is of a real person in appearance, action, or speech, which appearance, action, or speech did not actually occur, and which would cause a reasonable person to believe the appearance, action, or speech occurred. So there's really a lot going on there, but essentially it has those elements of that there has to be some form of manipulated or generated media that creates that realistic, but it's a false image, audio, or video, and that a reasonable person would believe that that image, audio, or speech occurred, is what it boils down to. Subsection B on page 3 provides then where we get into the unlawful portion of this, and provides that a person engages in unlawful dissemination of misleading synthetic media when he knowingly and intentionally disseminates synthetic media, knowing it to be synthetic media, without displaying clear and conspicuous notice in a visual synthetic media, or if it's in a audio, that they provide disclosure identifying it as synthetic media at the beginning, at the end, and if it's longer than 2 minutes long, interspersed at intervals not greater than 2 minutes. And that provides on page 4 in paragraph 2 that they also have to do that or disseminate that media with the intent to mislead others about the appearance, actions, or speech of the natural person represented in the synthetic media. Subsection C provides that any person who is depicted or misled by that synthetic media in violation of subsection B, that they may maintain a civil action to enjoin or restrain the dissemination of the media and may seek damages from the person who disseminated the media. And a court may award, we see in those paragraphs, equitable relief, damages, costs and fees, including attorney's fees. And one of the, I guess, bigger policy questions here, exemplary damages, in an amount not less than $1,000 per plaintiff. On page 5, subsection D just provides that the Attorney General may enforce and investigate violations of the article. E provides that the Attorney General or any district attorney may, on behalf of the state, bring an action for the temporary or permanent injunctive relief or other relief from a court of competent jurisdiction. And the court may award restitution when appropriate to any person suffering loss because of a violation of the article. Subsection F provides that the article shall not prohibit actions under other statutory or common law provisions against conduct or practices identical or similar to this action. So that subsection is basically saying you can still apply any other law, but if you want the provisions of this act to apply, it's got to be brought under this article. But it doesn't take away from any other causes of action or anything else that might be out there. Subsection D provides that a person, or G, excuse me, this provides a criminal element to the bill and provides that the person who violates subsection B, which we went through earlier, and who does that with malicious intent to influence the outcome of any election within Wyoming or to facilitate any other criminal act guilty of a misdemeanor, punishable by up to 6 months, a fine of $750 or both. Subsection H then provides that dissemination of synthetic media protected under the First Amendment or under Article 1, Section 20 of the Wyoming Constitution shall not be deemed a violation of this section. The act would be effective July 1st, 2024, and I stand for any questions.
Thank you, Mr. Hopkinson. Any questions? Committee? Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. Mr. Hopkinson, on bottom of page 5, line 22, 23, it says malicious intent. Those words that you mentioned, can you maybe just provide the committee a little bit of background on that from a legal perspective and what that includes?
Mr. Hopkinson.
Thank you, Mr. Chairman. So in discussion and as the working group kind of looked at this bill, there was an intent to require a little bit more for there to be a criminal violation as opposed to just the act of disseminating synthetic media, knowing it's synthetic media. So through that discussion, came up with the term malicious intent. It's an effort to require that there be a little bit higher of a level of criminal mindset for someone to be guilty of a criminal violation. The term malicious is used a few times in the criminal statutes, but ultimately it would be up to a jury to decide if the person acted when they disseminated that media maliciously.
Great follow-up, Mr. Chairman.
Mr. Co-Chairman, no follow-up.
Okay. Committee, Representative Singh.
Thank you, Mr. Chairman. Mr. Hopkinson, can you talk to us a little bit about why we've landed on 2 minutes each on page 3, line 22?
Mr. Hopkinson, go ahead.
Thank you, Mr. Chairman. That certainly a policy question for the committee, but that arose. There are similar statutes, and if I recall correctly, this one is Washington. Their statute is geared towards elections, and so it is limited to basically disseminating to influence an election or of a candidate, essentially, or someone that's seeking public office. But in their statute, prohibiting that dissemination for a candidate, it has that 2-minute requirement throughout the audio portion. So that's where that came from.
Any follow-up, Representative?
No, thank you.
And I'll just note that I believe there are 4 states that have similar legislation that are specifically related to elections. And so they only cover candidates during elections as opposed to the general public. In the discussion of the working group, it's understandable why that's a priority, but at the end of the day, the idea that we would provide protections for candidates but not provide protections for the general public seemed a little overly selective. And if we were putting forward good policy, it should be good policy that protects everybody. That was the decision that was arrived at. That said, you can see that the prioritization or one of the ways to draw the misdemeanor charge was to attempt to manipulate an election. So that was the emphasis that was arrived at by the working group. Any additional discussion on that point or further questions? Mr. Co-Chairman, I'll just note a couple of other points of discussion because I think each is worth spending some time thinking about and drawing the attention of the select committee to. The structure of the first definition on page 2, record, was a new addition as well, which is based on broadening the definition of what it could be rather than some video of something or an image of something. Record is already in statute, and you can see the definition or the staff comment that broadens it to, again, a statutorily consistent definition for record, but allows the synthetic media to be in a variety of forms. We had discussion of ensuring that at all times there would be intent to mislead, which is an important aspect of it. Knowingly and intentionally disseminate with the intent to mislead sets a pretty high bar. The private right of action aspect of this is something that draws a lot of concern and from opponents of this type of legislation because of concerns that it would lead to frivolous lawsuit. That was another point that was discussed by the working group. And obviously in Wyoming, we don't have a legion of consumer protectors that are there to file lawsuits every third minute, like many of the states that are able to limit the private right of action. And the other concern is realistically, any limitation on a private right of action is just that. It's a diminishment of individual rights where you're denying access to the courts for people. And the idea that we would deny access to the courts, grant a new protection while simultaneously denying access to the courts seems counter to the rights of the individuals of the state that we're trying to protect. And Mr. Co-Chairman, the final thing that I draw the committee's attention to, because it's new, is the H paragraph on page 6. Just trying to reemphasize that nothing in this legislation is shall be allowed to diminish First Amendment constitutional rights or rights under Article 1, Section 20 of the Wyoming Constitution, because obviously we're trying to balance rights of speech and at the same time protect individuals from abuses through synthetic media or misleading information. So that's the tension here. Hopefully we're in a good place. We'll hopefully find out a little bit more through testimony. But any questions before we go to public testimony? Further questions? All right, seeing none. Thank you. All right, going to public testimony, starting off with any agencies. I don't think we have any agencies that are providing testimony on this, but on the off chance that somebody showed up, open to agencies. Seeing none. Okay. Anyone in the room like to provide public testimony at this time? Please join us. please introduce yourself to the committee and who you're with, and the floor is yours.
Good morning, Mr. Chairman and members of the committee. My name is Ruthie Bargo. I represent TechNet. We are a national network of executives in the tech industry. We represent over 100 tech companies across the country and around the globe. We represent companies that work in the sectors of artificial intelligence for the relevance of this bill, e-commerce, the sharing and gig economies, transportation and cybersecurity, to name just a few of those. We sent a letter to the committee last evening for additional background, but I wanted to make sure that we were present to answer questions, as this is a very critical topic, and we very much appreciate the committee's work on this. As you mentioned, many other states are working on this topic, so it's very timely, very relevant, and it's a very critical issue. Our concern with this bill has nothing to do with actually addressing those sorts of deep fakes that would be, especially mimicking another person. There are emerging cybersecurity concerns that where deepfakes have been used. We completely understand all of that. For us, it's about right-sizing the regulation and making sure that it is appropriately targeted to the problem statement that the members of this committee and the working group have identified. So our comments are aimed to be substantive towards those concerns. Right now, we very much appreciate that the definition of a synthetic media has been narrowed. It has been improved from last time, and we appreciated that you took some of our feedback around natural persons, limiting it there. But we still see a little bit of subjectivity in this language. Anytime the regulated entity is unclear about what the line of regulation is, we find that to be a problematic regulatory approach. So we want to make sure that that regulatory line is clarified. We do, sorry, just to reorganize my thoughts. We do want to make sure that this is appropriately targeted towards what is actually a deep fake. And we do see that some narrowing could still be done. With the definition, the fact that this hinges on the definition of an intent to mislead, which is, we're unclear on if that is actually a legally defined term anywhere in Wyoming statutes. We have not had the opportunity, nor am I an attorney, to actually cross-reference with Wyoming statutes or libel laws. Is the intent to mislead somewhere actually defined where that could be actionable, or is this going to go to a lot of litigation or common law interpretation? We would just like to understand where that is, because it still seems overly subjective. Additionally, we are concerned, even though paragraph H was added on the First Amendment, and thank you for mentioning that, Mr. Chairman, we do still have questions around if there is a private right of action and if it hinges on subjective language such as intent to mislead or feeling that you are misled. How does that actually work with a First Amendment? Because that seems that would exclude a lot of cases that could be filed from the existing civil liability in this bill. And how does that actually work legally? So we want to be clear that any First Amendment protected speech absolutely would not be actionable under this bill. We think that that's of paramount importance, and other states that have looked at this have made sure. Michigan just passed House Bill 5141 about a week ago, and they had disclaimers in that bill that both excluded parody, satire, as well as disclaimers for the online platforms, which is something that I will also address. We cannot ultimately support the private right of action, so we do ask that paragraph C is removed in its entirety. We understand that your concern is access to the court system, that providing consumer protection, but also denying access to the courts. We understand that sentiment. In practice, though, we do see Attorney General enforcement as being appropriate with this bill. And that is what other states have done, is focused it mainly on Attorney General enforcement. So we must oppose a PRA at this time in paragraph C, while we do understand the intent of what the committee is trying to accomplish there. We do think that exemptions for the platforms that host online content, especially when they have absolutely no role in the creation of this content, when they're not aware that it is being posted, this gets into both First Amendment and Section 230 issues, plus dormant commerce clause, as you see with a lot of other social media bills and cases that have been in the courts. So we do think that disclaimers for the online platforms would be necessary. You did also see that in that Michigan House bill that was just passed, where they did host even an additional exemption for online platforms when they were not aware whether or not the disclosure was done for generative AI content. We do appreciate the watermarking approach, but they even provided exemptions for the platforms who were not aware whether or not that was done because it isn't their content. And then finally, we do think that an exemption for the use of AI and machine learning for cybersecurity and anti-fraud purposes would be a prudent exemption to also add, because there are a lot of companies that are working on developing AI and machine learning tools to combat cybersecurity risks with AI. So we want to make sure that this is taken into account with this bill and does not create any liability for those companies, some of which are very small. And then we do see that the civil penalties and the criminal penalties seem a little bit misaligned. The civil penalties are a little bit more expansive, so we weren't sure if that was intentional, but it makes sense to balance those a little bit. We just thank you for listening to our concerns. This is a very difficult area to legislate. You are right on the cusp of what so many states are looking at, and we absolutely appreciate being a resource to the committee. Thank you.
Thank you, Ms. Barco. Appreciate you being here. I appreciate your letter that you sent. Thank you very much. Committee, any questions for Ms. Barco? Go ahead, Mr. Kaufman.
Thank you, Mr. Chairman. Thanks, Ms. Barco, for the comments. I was just curious if you could expand a little bit on the recommendation to remove the private right of action.
Ms. Barco, go ahead.
We see, especially with something that can be taken subjectively, we don't see that a private right of action actually provides a benefit. We see that when you can properly have attorney general enforcement, we don't see a private right of action as actually providing a benefit. We think that this is an emerging area of technology, and when that, in order to support that innovation, attorney general enforcement is more appropriate than having civil liability. To not, because when businesses are looking at that liability, especially when it's limited to one state, the internet doesn't stop at state lines, as we all know. This is going to make businesses make that judgment about whether or not they want to prioritize Wyoming in such a sense, if they see civil liability here, essentially. So that's why we think that having the attorney general's eyes on it is better.
Mr. Kaufman, follow up? Thank you, Ms. Barco. Further questions? Mr. Co-Chairman?
Thank you, Mr. Chairman. Ms. Barco. So if I understand your argument correctly, you're saying that the people that your organization represents, and the companies they represent, cannot be held liable for this type of dissemination of these types of media. Is that, am I hearing that correctly?
Ms. Barco?
Thank you, Mr. Chairman. Mr. Co-Chairman, so that is a standard practice in these other laws, and the other ones, as the chairman mentioned, were focused on election deepfakes. So because of, and I believe the legal reason would be because of Section 230 and the First Amendment, as well as Dormant Commerce Clause, between all of those interacting areas of law, and a legal expert or someone from the Attorney General's office could reinforce or check my math here. But when you're talking about whether or not those platforms, if they are just hosting content, they're not creating the content, they're not necessarily checking every single piece of content, that's where we also get into content moderation discussions. If we're asking them to be liable for this content that's hosted on their platforms, then you're also saying that they need to be legally liable to take it down. That has erupted into a lot of other content moderation cases that are currently moving through the courts or have been stood with injunctions. So there would be constitutionality issues.
Mr. Chairman.
Thank you, Mr. Co-Chairman. So I'm going to take that as a yes. So if you're saying that they can't be culpable, you're saying that they can't bear any responsibility, it's not our fault. I mean, I have a hard time with that. I mean, I think, analogous situations, we obviously know that there's a serious drug problem in America, fentanyl. All the precursors to that come from China and India. Do they bear some culpability in this serious problem that's really affecting our population here in the United States? I would argue yes. Does all the responsibility lie with them? Of course not. Obviously, it's up to us for all the other remedies and options, but to say that they have no responsibility or culpability in this entire problem, I think is just wrong. And so I certainly appreciate your concern, but at the same time, this is a serious problem that has serious consequences, and for the folks who are playing some role in this happening to say they are not culpable at all, I struggle with that argument.
Ms. Barco, thoughts?
Thank you, Mr. Chairman and Mr. Co-Chairman. I think those are apples and oranges when you're talking about a liability perspective. These platforms are not saying that misinformation should be perpetuated by any sense of stretch of the imagination. What they're saying is watermarking is a really good approach. What you have in this bill is a good approach as far as making sure there's audio watermarking for people who are visually impaired and making sure that there is disclosure of generative AI. They are simply saying that it is unreasonable to expect them to be held accountable if some piece of generative AI is hosted on a platform and before they can take it down or before they see it or what that liability is. So they are not saying that misinformation should be perpetuated. Again, we are talking about right-sizing the regulatory approach per the problem statement that this bill is trying to solve. And watermarking is a very good way to start that, even just from the amount of generative AI content that is out there. So we have no argument with the fact that something should be done about this, and that if your image is, maligned by generative AI content by an opponent in your election, we're not saying that that is something that should be tolerated.
Yeah, Ms. Barco, I'm going to follow up on his question. The language was very carefully, knowingly and intentionally disseminate, knowing it is synthetic media, so you have to meet those standards with an and. You have to simultaneously being disseminating, it has to be knowing and intentional of the synthetic media, and you have to know it is synthetic media. So imagine a circumstance where a platform is distributing synthetic media, somebody else generated, and they don't even know who it is, which is a commonplace type of event. At that point, they haven't achieved any of these standards, obviously. They're not knowing that they've done it. But they find out, somebody sends them a takedown and it says, all right, you are perpetuating synthetic media. This is not real. At that point, that is when it becomes a question of knowingly and intentionally distributing it in synthetic media while knowing that it's synthetic media. How is that an unfair standard for a platform? Because realistically, the moment you know that you're intentionally and knowingly disseminating synthetic media, whether you're an individual putting it on your website or whether you're the platform, you have moved into the culpability space, where before that, you weren't acting with any bad intent. So what are your thoughts on that? That was carefully crafted for this specific discussion.
Absolutely. Mr. Chairman, I think that of paramount importance here is because we did recognize that the language was very intentionally narrowed from the previous draft. So we absolutely appreciated that. It's moving in the right direction. It's not so much that language, because we agree with the way that was narrowed. I mean, you are trying to say that it is only by sort of their direct action to either take action or not. I think that it really stands in some of the other subjectivity that it is, if the person essentially feels that they're misled, they can file a suit. That's where it kind of gets into issue there. And I do point to the fact that as states are legislating this, it's very important to, have that peripheral vision about what other states are doing to not create a patchwork of different state laws that create conflicts there. So these disclaimers for the online platforms are pretty standard practice. We can follow up with additional legal reasons why. And then I would also point to the fact that each online platform does have their own standards of practice essentially on their platforms, where they talk about, what speech they will and will not tolerate from a hate speech perspective, from bullying, from all the other content that they will not allow on their platforms and how they approach it. So this would kind of fall into that as well.
Sure. Ms. Barco, we're all kind of familiar with those discussions, though, and they might not be as robust as we're all comfortable with, and thus the legislation. On the idea that an individual can have standing for civil action based on the fact that they were misled, do you see that as being independent from the person or that is engaging in unlawful dissemination having to knowingly and intentionally disseminate it, and knowing that it's synthetic media? I mean, there's the idea of who has standing to bring a claim, but then there's what constitutes an action that can be claimed against, and I don't see that obligation shifts based on this language. What are your thoughts?
And I think the concern we actually had was really just in paragraph C with the language around, and I'm sorry, I forgot my actual copy of the bill to reference it, but it was more in paragraph C that we were unclear as to how that interacted with existing Wyoming statutes or libel laws. And we did not necessarily have time for a thorough review, but that is our question more about how I believe it's intent to mislead or, the previous language.
Is intent to mislead, and then in C paragraph, it's any
Okay.
person who is depicted by or who is misled by synthetic media, disseminated, et cetera.
The fact that it is misled, which I think is why some of those other state laws included an express exemption for parody and satire, because someone may consider themselves misled by media that is parody or satire, but they may not understand that. So that's where we feel that these exemptions provide regulatory clarity, and that's why they're important.
So how does parody or satire provide clarity? And this is a question that I was going to go back with. Some of what you're asking for is clarity, and some of what you're asking for is kind of not clarity. The first thing anyone would claim if any allegations or charges were brought against them is this was satire. And we saw that in the other laws, and we considered that, and that was the discussion is, of course it's satire when you get caught. To me, that's the glorious loophole that everyone can and should claim, because it seems to be available in all the statutes, as opposed to just calling out protected First Amendment rights, which includes parody and satire. So I don't understand how additional clarity is provided by saying it was satire if the intent was still to mislead. I guess I'm missing how that clears things up.
Thank you, Mr. Chairman. And that's where we do think that the improvements that were made in the definition of synthetic media are helpful, where it was limited to a natural person, where it's talking about depicting actual events. We think all of that does help reinforce that. So we're not saying that you absolutely have to have an exemption for parody or satire. We were simply pointing to what other state laws have done,
Right.
aiming towards that same regulatory clarification.
Yeah.
So our question still remains about how the word misleading would work, especially from a civil stance, but that's the main crux of our legal question there.
Understood. Okay, thank you. Committee, any additional questions? Go ahead, Representative Singh.
Thank you for being here today. My question for you, can you explain a little bit about how the algorithm affects how information is shared for folks who, so I have social media accounts, right? And if I've seen folks who they've talked about how they shared something that they thought it was the truth. And so they shared it with their friends, but then eventually it was flagged as false information. Can you tell me about how the algorithm will perpetuate or diminish how that information is exchanged on your platforms?
Ms. Barco?
Thank you, Mr. Chairman. Thank you, Representative Singh. That is something that I would be happy to follow up with additional information, and that the algorithm has been maligned in a sense until we only see the negative things and not necessarily how it's also helping on the positive side as well. But we do have a lot of materials on that. I just do not have it right now, but I would be happy to follow up with you. There has been a great deal of debate about that on the positive and the negatives and how it's actually working. So I'd be happy to provide that.
Thank you, Ms. Barco. Any follow-up, Representative Singh?
Not right now, thank you.
Thank you. Further questions for Ms. Barco? Seeing none, thank you for your testimony. Appreciate having you here.
Thank you.
All right. Anyone else in the room like to testify on 24 LSO 236? Mr. Garrett, come introduce yourself to us. Some of us may not know you.
Well, I'm grateful for that, as I get to reintroduce myself for the first time to at least some members of this committee. Mr. Chairman, members of the committee, my name is Richard Garrett. I'm a resident of Cheyenne, born in Wyoming, and I appreciate all of our freedoms in this state. I'm reluctant to sit here and in opposition to this bill, frankly, because I know a lot of hard work has gone into it, and I know that everyone on this committee is struggling to do the best that they can to protect the people of Wyoming from being manipulated and our culture subverted by those that have malicious intent. So I'm grateful to you for turning your attention to this, but I've got to say the First Amendment just trumps it all. And for now, and until we can figure out a better way to deal with this, I think that that's the rock that we have to plant our flag in, that our First Amendment rights need to be protected, and they will be protected if we all stand firm. I'm old enough to remember when I wasn't there when it was broadcast, but the stories were still shared around the nation and even the world about the broadcast War of the Worlds on the radio, and there were no watermarks at that time, but people were panicking in the streets, at least by accounts, that Martians were invading our world. I am young enough to enjoy late night television and all the parodies and satire that happened there. If I inadvertently share one of those parodies or satire, I am going to depend on the First Amendment to protect my rights. I'd conclude by saying that this last weekend here in Cheyenne, I got a chance to see a play, a locally produced play called Fahrenheit 451. And that play dealt with a dystopian future. It was written by a guy by the name of Ray Bradbury in 1953. And he predicted a time when all books, every book in the world would be banned. And there were people that actively enforced that banning of books, every single book. Ray Bradbury also predicted television walls. And Ray Bradbury in this play also predicted Alexa and Siri and all the things that I enjoy using. I tell my watch to help me find directions to committee meetings and so forth. So that's kind of the future that we're headed towards as we ban free speech, or as we attempt to grapple with this issue. And again, I know that each and every one of you has our interests, our safety topmost in mind, and I genuinely appreciate that. And I hate coming in at this hour and when you've done so much work, but the First Amendment is the First Amendment. Every amendment counts. And so I thank you for your service and allowing me to express myself as a citizen of the state of Wyoming, Mr. Chairman.
Thank you, Richard. Any questions, Mr. Garrett? Mr. Co-Chairman.
Thank you, Mr. Chairman. Mr. Garrett, in relation to your comments, how do you feel that Roman I on page 3 impacts them?
I did not-
Specifically the watermark component.
Mr. Chairman,
So
Mr.
just to
Co-Chairman.
make sure, Mr. Garrett, that you're saying that even if there's a watermark, it's still a violation of the First Amendment?
Mr. Chairman, Mr. Co-Chairman, I did not bring a copy of the bill up with me, but I do remember that section. And I'm not a constitutional lawyer, and I'm not sure that watermarking or lack thereof is impactful, honestly. I think it's really a First Amendment question, and all speech is free, and we need to protect that right of free speech. And I don't think that we need to file a disclaimer of some kind. I'm sorry, Mr. Chairman.
So, Mr. Co-Chairman, follow. So, Mr. Garrett, by that same rationale, is it an infringement on the First Amendment to put paid for by on campaign material? Correct?
Mr. Garrett?
Mr. Garrett?
Those protections are in place, you're right. You're absolutely
So-
right.
Sorry, Mr.
ahead,
Co-Chair, this is,
continue, Mr. Co-Chairman.
forgive me for perhaps being a little slow in the uptake here. So you're saying that putting paid for by on campaign material isn't a violation of the First Amendment.
No, Mr. Chairman, no, sir, I'm not saying that at all. I don't think it's a violation of a First Amendment right to require disclosure of payment of a political ad. I'm not sure I see the parallel, and I hope you'll forgive me for that.
So, Mr.
Go ahead.
Co-Chairman, so then what's the difference between simply saying, put out whatever media you want, your freedom of expression? All we're saying is that if you are depicting a real person doing something or saying something that they haven't actually done or said, you just simply have to put a little watermark that says either deepfake, synthetic media, this is parody, something along those lines.
Mr. Garrett?
Mr. Chairman, Mr. Co-Chairman, a great point, and I think that that's probably something that you all struggled with in your work during the interim to try to resolve. I candidly, again, do not see the parallel. I think that it's appropriate to disclose the origin of a campaign ad and for the public to understand, or at least have a chance to better understand who might be supporting or promulgating information. But I don't think a campaign ad is necessarily satire. I think each one of you take your campaign ads very seriously and try to present yourselves in a way that is reflective of your constituents' values and your efforts to serve them. I admit it's a tough area, and that's again why the work of the committee was probably so difficult during the interim. I think I'm just going to have to disagree.
Mr. Co-Chairman,
So-
anything further? Go
Mr.
ahead.
Co-Chair, so you're saying that there's no parallel between both situations where you are being required by regulation to put some type of disclaimer on the media? You don't think there's any parallel there?
Mr. Chairman, Mr. Co-Chairman, no, I do not. That's me.
Further discussion? Mr. Garrett, I have a question. So you have your right to your free speech, but do I have a right to take an image of you and have you say things that everyone believes is you saying those things? So I'm replacing your speech. The public generally thinks, look, this is Richard Garrett saying, I hate puppies. I passionately hate puppies. And then the world quickly believes that Richard Garrett is a puppy hater, which is obviously not true, Richard. We know that you are a friend of puppies, as we all are. This is the complexity. It's someone else using your speech as their free speech. And you have, as an individual, other rights. You have rights to privacy. You have rights of ownership of your intellectual property. You have a bundle of rights that my ability to impersonate you and discredit you and slander you have been recognized as being limited because where our two interests come together, there's going to be a tension and we have to draw that line. It sounds like because it would be me claiming it to be my speech to impersonate you to make the world believe that you're a puppy hater is paramount to any rights that you have to respond to that. And is that accurate?
This is why I was reluctant to come in front of this committee. Thank you for acknowledging that I'm not a puppy hater.
You are not a
But
puppy
that's,
hater.
It is
Yeah.
on video and it's
Absolutely.
permanently stored now on LSO servers somewhere in this building. A little bit closer to home, I have been misquoted. I'm sure all of you have been misquoted at times, and found that not only disturbing, but perhaps even harmful to your reputation. I know in my case that was true, but I was misquoted by a publication that has a duty to, or a role, I should say, in helping us protect our freedom of speech. And as hurtful as that was, I could not possibly have any cause of action against them for their misquote. I worked to try to ameliorate it, to ask them to mitigate it, and to some extent was successful. I'm sure that's, again, an experience you all have had, but, you know, if somebody wants to ruin my life and call me a puppy hater, I guess then I have to stand up and say I'm not, and hope that my friends stand with me and say Richard Garrett is not a puppy hater. And
You know, nobody says that.
Nobody says
Yeah,
that.
just to be clear.
stipulate that, okay.
But Mr. Garrett, on this one, and I appreciate this passion for the First Amendment speech, but again, no right is absolute when it starts to infringe on someone else's rights. In fact, the First Amendment we know is certainly not an absolute because we do have slander and libel laws. We don't have the right to yell fire in a crowded theater. There's unquestionable time, place, manner, circumstances on freedom of speech that have been upheld by the courts, and for good reason. And usually that reason is because it infringes on someone else's rights. Your right is absolute so long as it only affects you. But when it starts affecting other people's rights, that's when you have some contention.
Mr. Co-Chair?
Go ahead. Senator.
So I'm refraining to providing any comments because I don't necessarily want them directed at Mr. Garrett. I appreciate his comments here as an ardent defender of the First Amendment, which is obviously fundamental and of our greatest and utmost concern. But with that, I think I understand Mr. Garrett's position. Rather than using him as my debate material, I will refrain and engage in discussion with the committee on the bill.
Thank you. Any further questions for Mr. Garrett?
Mr. Chairman.
Go ahead.
Thank you, Mr. Chairman.
Andrew.
Mr. Garrett, are you comfortable with there are some examples brought up of things that someone might fall into, but there are remedies to these problems already. We have torts. You can sue somebody for slander, for false light, for appropriation of name and likeness. Are you comfortable with those being your remedies, with being able to sue somebody for speech, for you being able to sue somebody for speech that might have harmed you? I mean, do you think that those maybe should remain the remedies that are available rather than, really convoluting criminal law with free speech?
Mr. Garrett?
Mr. Chairman, Representative Andrew, yes.
Yes. Thank you. Any follow-up, Representative? Thank you, Mr. Garrett.
Thank you,
Further
committee.
questions?
Thank you,
Thank you.
Senator Nethercott.
Any further testimony in the room? Further testimony, seeing none. Let's go online. I believe we have Daza up first. Is Daza online?
We do,
All
Mr.
right.
Chairman.
Let's bring in Mr. Greenwood.
Thank you very much, Mr. Chairman, and members of the committee. I'm Daza Greenwood of civics.com, and also a member of the working group with this committee that helped to develop this legislation. And I want to testify primarily in favor of the legislation. I support this bill and its efforts to combat harmful deepfakes because the pressing need to address the challenges posed by deepfakes and other forms of synthetic media in the age of these new capabilities that we have now with generative AI and their wide accessibility and use is pressing. Things are different now, and it is entirely appropriate. And I think it's a responsibility of bodies such as this to look at how law must be adapted to respond well to these new capabilities and the consequences of them. I think the deceptive potential of these technologies does pose a significant threat to personal reputations and public trust, and just the very integrity of information and what is a fact itself. However, as I mentioned in the working group, I do think the bill, while it's really improved a great deal, the current version of the bill does still have a rather broad scope, and it risks limiting free speech, and the standard for civil liability is likewise perhaps a bit too broad still. And I do have some suggestions on possible ways to mitigate these issues, but first and most important, I just want to emphasize the reason I support the bill and support you continuing to work on it, perfect it, and ultimately I hope that something like this is enacted, is because it rightly targets the malicious use of synthetic media, aiming to protect individuals and the public from deceit. And it brings necessary legal attention to a rapidly evolving landscape, and takes a crucial step toward more responsible media consumption and creation. And so now, as promised, some of the issues that I think still exist in this version of the bill. The first one is, I think it's commendable that there's a broad exception for First Amendment. That's very good. But as written, I think it still leaves some lingering questions that don't and shouldn't need to be litigated. I think there's a risk, as others have testified, of over censorship under the current language. And my suggestion would be to clearly delineate exceptions, like clearly, specifically, and explicitly delineate exceptions for parody, satire, political commentary, things like that, to safeguard the freedom of expression that the same technology also enables. So that's the first thing. The second thing is a little bit more subtle, and it goes down to this intent to mislead. Now I'm looking at the civil prong of the bill specifically, and to me that seems rather broad and possibly too broad, and it leaves me asking, as I look at other types of torts or kind of equitable remedies or causes of action that are sort of in this genre of legal action, it makes me ask, where's the malintent, or lacking malintent? Where are the serious consequences if there's no intent, if there's no heightened intent requirement on the civil side? So I think that there does need to be something. The other thing sort of compounding this is as others have mentioned, the phrase intent to mislead is itself new, and new's not always bad, of course, and this is an innovation committee, but it does, if it's not necessary to have a new standard, and other existing standards are adequate and appropriate and proportional to what's needed, that they're, I think, better. And I think just by plain reading of the word mislead covers a lot of territory, and it may cover too much territory in order to be proportional or appropriate to invoke civil penalties. I think some possible fixes for this would be to require that the actionable intent be something along the lines of knew or should have known that the speech would cause substantial, and then fill in the blank, like emotional distress, reputational harm, some kind of like negative actionable impact, that would actionable as in you could sue for it or be entitled to some remedy, or maybe it's acted in reckless disregard for the high probability that the speech would result in imminent harm, some kind of harm. or that you intended the speech to harass or intimidate the subject is another facet that you might be getting at. The actual malice, like the knowledge that it was false, or reckless disregard for falsity is another kind of oldie but goodie. Acting negligently in failing to adequately verify or corroborate the speech before disseminating it is, extremely time-honored kind of approach in tort. So now we know kind of what we're arguing here about negligence with respect to failing to adequately verify or corroborate the media before disseminating it. These are all, I think, better than just kind of leaving it with intent to mislead, which is carrying a lot of weight. And I don't know if that language is up to carrying that weight. And so in conclusion, while addressing manipulative deepfakes is crucial, I think the regulations have to be careful to set kind of clear and well-grounded standards, not to curb beneficial and protected creativity. And with certain adjustments to the intent requirements and or requiring actual harm, as well as clarifying key exceptions. I think I'm very much in favor of this bill, and I want to thank the committee for the opportunity to have served on the working group that's been helping to draft it, and for the opportunity to testify today. Thank you.
Thank you, Mr. Greenwood. Questions for Mr. Greenwood? Representative Singh, go ahead.
Thank you, Mr. Greenwood, for being here today. My question is about how does information refresh itself within news-giving algorithms? So let's say recently someone famous just said that he was giving up a habit that he is notorious for, right? He's given this up, and afterwards it turns out that he was actually manipulating his words to advertise a product that didn't have anything to do with his personal actions. How quickly would a AI system be able to recognize that what he's just said is truth or is not truth? Thank you.
Mr. Greenwood, how long would it have taken for that story to go up in smoke?
Thank you. Jesus. So the system that I'm thinking of for answering this question would be a modern, powerful, like foundational generative AI model, such as GPT-4 or Claude's or Anthropic's Claude 2 100K. And what I'm thinking is, how would it, for those systems, what input would I have to provide it in order for it to have the relevant information necessary to provide an output that would say, if I understand the question correctly, that this was basically that this synthetic media was misleading and would be actionable under the bill. So first of all, let me, if I may, through you, Mr. Chairman, ask the member of the committee, do I understand the nature of the question correctly, which is how could a system identify that someone's actions, such as this celebrity who's misleading the public, how could it and how quickly could it identify that as being misleading and not genuine, authentic speech? Was that the scenario?
Representative Singh?
Sure. Thank you, Mr. Chairman. Let's say that I put in 10 different requests for artificially generated outputs of speech from a particular celebrity, and 60% of those requests referred to something that they had said in the past, which is factual. However, later they redacted that statement. Would that, under this bill, be considered a criminal offense?
Mr. Greenwood?
Oh, I think I understand better now. I apologize. I think I misunderstood the question initially. And so to just confirm that I've got it now, is the question, if I were to use an AI system such as ChatGPT, for example, or Claude, to inquire about a public figure's statements on a topic, and it provided me misleadingly incorrect information based on, for what I think what you said was stale information, or another kind of very important source of a potential kind of cause for that would be it's hallucinating, so-called. It just completely fabricates what had happened. Then would that potentially trigger liability under the bill as it exists today? Is that the question, sir? I asked through the chairman.
Representative Singh?
Yes, thank you, Mr. Chairman.
Daza, back to you.
Thank you. Well, let's see. I'm just gonna scroll through the bill and try to do a legal analysis. That is not the scenario that I typically think of as anchoring this bill, but it is a good one. So it's definitely synthetic. Well, okay, I guess the first question is it synthetic media? So I guess the first thing I would say is if we're looking at a system such as like ChatGPT or Claude, and it's giving me like a text output, it's pretty, I don't think it's reasonable to ascribe that to the person themselves ordinarily, but I can think of some situations where I could prompt it in the right way so that it would appear to be giving me something like, factual news about that person. So I guess I can say, I can imagine situations where we would have synthetic media. And then the question becomes, is there an intent to mislead? The first thing that I think we run up against, if we're getting the information from an AI itself and not from a human being who is like using synthetic media with an intent to mislead, is I think it's really hard and probably impossible at this point to ascribe intent to an AI system. Intent has a kind of cognitive root that is part of consciousness and being like like alive, and at a certain level of sentience to have intent. Like arguably, an amoeba or whatever, when you give it stimulus, it does something, it's reacting. Does it have intent? We say there's like kind of higher brain functions needed for that. And they're of a certain type. And I don't think anybody is saying that artificial intelligence possesses intent at this point. That's partly why in the last session I was suggesting AI should and automated systems should not be in the role of being the sole operator of legal entities for algorithmically managed LLCs, partly because they can't have intent, they can't be accountable, they're not like people in the sense that we want to have people that are legal persons. And one of those facets is it doesn't have intent. So I don't think I need to read much further in the bill to say I don't see how that would trigger liability.
Thanks, Daza. Any follow-up, Representative Singh? Seeing none, any further questions for Mr. Greenwood? Mr. Greenwood, I have one quick question, and it gets back to similar discussion from a few minutes ago, having clarity on one side and creating vagueness on the other. The parody and satire edition is so subjective that I don't see how you have any bill left if you include an open, explicit exemption for satire or parody. Anyone would always say it was satire. I mean, it could meet the rest of the bill. You could have an intent to mislead. It could be entirely realistic. There could be nothing funny about it. But satire is certainly in the eye of the beholder or the creator, depending on the circumstance. So how can that addition, while I understand the intent to protect satire, if you allow an explicit, if it's satire, you're always off the hook, how does that leave anything left?
Well, thank you for the question, Mr. Chairman. And may I pose a clarifying question to you?
Sure.
Which is, in the current language in the bill that points to the First Amendment and the kind of corresponding law in Wyoming, is satire, are satire and parody not already included in that? So, I mean, do you believe these are already defenses under this exception or not?
I do. It's just that they're not a blanket exception, so to speak. You can't simply claim it. It's not an override. It is a feature of the First Amendment where those First Amendment rights would be balanced against the law, and then you would have what is typical limitations where you have a circumstance where they would be able to claim that satire, but it would be balanced against a statute. If you say blanket exemption, it effectively eliminates the bill. Do you see the difference there that I'm trying to get at? You always have the capacity to use your constitutional rights as a defense, and that should always be taken seriously. But if there is a statute that says, all right, you have the intent to mislead, that gets more into the fraud area at that point. And satire and fraud probably come into play from time to time also. It would then be up to a court to make a decision. All right, are you in your constitutional rights area, First Amendment protected speech, or did you commit fraud? You have a crime against fraud. It seems this is similar to that circumstance where we're creating a crime against the action where speech is used to conduct that action. It's the action of misleading, not the action of the speech. Nobody cares about the actual speech. It's you have misled someone. You have committed a type of fraud. In this case, using synthetic media to intentionally mislead. So there is not, to my knowledge, and I guess I can look over to other better experts, I don't think there's anything in our fraud statute or our libel statute that specifically says, unless you're being satirical. Yeah.
Mr. Co-Chair, if I
Senator
can, and this is maybe to Daza as well. I think there's two purposes that I heard Daza say, or two primary concerns of why he thinks the bill is still challenged, although supports it. One is the First Amendment constitutional concerns, and then the second is potentially its breadth in the scope of its cause of action to potential litigants. Is that correct?
Deza, go ahead.
Thank you, Mr. Chairman. Yes, Senator Nethercott, that is correct.
Okay, thank you, Mr. Co-Chairman. And so it is helpful for us in separating out those two concepts because they are substantially different. And I think it's much easier to get your arms around addressing those concerns, whether or not you're trying to address a constitutional First Amendment concern, or whether or not you're trying to narrow the class of litigants, and then what those elements are for a plaintiff to prove. And so you can take on the second piece of narrowing the class of litigants and establishing the elements for a plaintiff to prove. We can, for the moment, set aside the constitutional concerns and treat it like any other type of cause of action. And so with that, or Daza, you provided those exceptions. Was your purpose in doing so in order to to provide more elements or more specificity as to limiting the scope of the cause of action or elements to the cause of action? What are those exceptions for?
Deza?
Thank you, Mr. Co-Chairman. And Senator Nethercott, the purpose of the exceptions that I mentioned was to clarify that those forms of expression, like parody and satire, are intentionally included within the broad ambit of First Amendment and corresponding law. And as I think others have testified, these are important. I think the example of War of the Worlds was something that was in the back of my mind as well, and countless others, as beneficial speech that for which legal action I think would not have been appropriate under an intent to mislead. Like if there was a problem, that wouldn't have been it, because it's good that we have these types of behaviors as protected, and I think it's somewhat ambiguous as to whether they are or are not protected explicitly. If that's the intent of the legislature, I think it would lead to litigation. And I think if it is the intent of the legislature to include these behaviors as part of the exception to the bill, it would be better to state so up front. If it's the intent of the legislature to not include this, but rather other aspects of First Amendment rights, such as political speech, but not satire, then I think it would be helpful to be explicit about that. But right now it seems rather ambiguous. And personally, I would favor a broader scope of First Amendment rights, and that I hope clarifies what the intent of my own testimony was.
Thank you, Mr. Greenwood.
Follow-up?
Follow-up.
Thank you, Daza. I appreciate that. It doesn't provide any clarity in my mind, and the reason why, I know, Daza, you're a lawyer, correct?
Correct.
I just want everyone to know that. So, and you identified this clearly, where the breadth of First Amendment case law in this country, which is the guiding factors of which we are relying upon, in addition to the language of the amendment itself, but really the breadth of this country's history of case law on it, does break out different types of speech and affords different protections to the type of speech. For example, political speech has more protections associated with it than commercial speech, correct?
Deza?
Yes, Senator Nethercott, it absolutely does.
Senator Nethercott?
And so parody could be used in commercial speech as well as political speech, correct?
Yes.
Thank you.
Senator
And the purpose of this really is just to kind of flesh out some of the challenges with the exceptions, and why it's very difficult for us to address the breadth and scope of some of these First Amendment concerns. What we do know is that the First Amendment does afford limitations on speech, correct, Daza?
The First Amendment there are limitations that apply to the First Amendment on speech.
And those limitations have been found to be constitutional.
Right, some certainly have, such as, the classic being "don't yell fire in a crowded movie theater," I believe is an example of the class that you're getting at, Senator Nethercott.
Yes, and/or time, place, and manner restrictions that we know our US Supreme Court has provided as the requisite limitations associated with First Amendment speech. Right?
Yes.
So the government can limit the location, the time, and the manner of speech. The court has found those types of limitations to be lawful depending on their application. And so keeping those considerations in mind, do you have concerns that that this bill draft is actually unconstitutional?
Mr. Co-Chairman, I would say to Senator Nethercott, I didn't perceive a constitutional problem with this bill. However, I hasten to add, I haven't practiced law in like 20 years, and I was never a constitutional lawyer, but I didn't see that. What I did see and what was prompting my suggestion to ensure that protected speech such as parody and satire, etc., are clearly included was that it may be ambiguous whether they were or not. It was not because I thought the bill was unconstitutional.
Thank you, Deza. Any follow-up, Senator? All right. Thank you. Further questions for Mr. Greenwood? Representative Singh?
Thank you, Mr. Chairman. Mr. Greenwood, when algorithms like OpenAI encounter questions from different languages, how does, I mean, are there multiple languages that are available on these services? Are you able to, let's say if I were to have a sentence that I had written in Mandarin and then put it in AI and asked it to give me an answer in English, how would that work? I don't even know if that's a service. So can you talk about that a little bit? Thank you.
Mr. Greenwood, quickly on that?
Yes, Mr. Co-Chairman. I can talk about that very briefly, and the answer is amazingly yes. This approach to computation, these large language models, the modern type that are kind of very general and used pre-trained transformers and have a lot of data like ChatGPT and Claude. They have a lot of surprising capabilities that I would not have guessed that they would have. One of them is pretty good translation. It's a completely different way of translating from like Google Translate, which is more kind of like fundamentally symbolic logic, where they've kind of programmed a bunch of equivalencies in, and they've kind of done it in the old way of computation. This is based on finding patterns in huge, very large corpus of data in high dimensional vector space, and being able to see the idea and transform it from one language to another, the same way you can transform ideas from like one domain within English to another, like an engineering idea to a legal principle. So it's able to see these deep conceptual patterns in ways that are astonishing. To me, it seems like an emergent capability that's getting closer to artificial general intelligence. And yeah, one of the surprising and very good capabilities it has is language translation. And people are leaning into this now in a lot of areas, including in law and in tax. I was just working on something where people have a tax practice that spans a lot of jurisdictions. And so this language thing is very useful. It has to be checked. It's not perfect. And there's some interpretation, but its ground level capabilities are quite good in general. It also depends on the language. Underrepresented languages, it doesn't do the patterns as well, but like, German, English, Spanish, it's really remarkable.
Thanks, Daza. Yep, go ahead.
Thank you, Mr. Chairman. Can you talk a little bit about what kind of databases are being relied upon for the interpretation and the the translation between these languages?
Let's take that question as an offline question. Daza will give you 3 hours, I promise, on exactly how all this works, maybe 4. You can do it in 5, Daza? Okay. I want to keep on schedule with regard to the bill. Anything else directly on the legislation? All right. Any questions for Daza on the legislation? Seeing none. Thank you, Daza. Appreciate it.
Thank you.
Up next, we've got Brendan.
Yes, Mr. Chairman.
Let's bring him in. Brendan,
Committee, hello. my new space. Can the committee hear and see me?
we can hear you. Please introduce yourself and let us know your testimony.
Great. Thank you very much, committee, for having my testimony. My name is Brendan Marr. I'm an MIT Media Laboratory alumnus from 1998. I was at the Media Lab at the time when Marvin Minsky was there, who was one of the founders of the thinking with the precursors to deep neural networks. I'm also on the working groups for digital identity and the decentralized, the DUNA Act, which we were working through yesterday. I have two comments, two directions that I hope will be useful for the committee. The first thing that I'd like to state off the bat is that I do concur with Daz's sentiment. The bill is going in the right direction. I also believe with him and Ms. Barco that further constraints are needed to make this workable in a way in which there's not a tremendous amount of litigation in the wrong areas. I also believe that Representative Western's constructs around the need for controlling liability is or having liability is utmost important. Having said all that, I will put forth two things that I believe might be useful for the committee to consider in keeping this bill moving forward, but also making amendments as we go forward. The first being in line with Daz's sentiment about, I think he said, exceptions, and getting toward Senator Nethercott's, discussion regarding all of these ways of carving out exceptions. It would be this. First and foremost, I believe with this statute that relates to AI, that it is very important to look towards the specifics of the way the problems arise most saliently, and I can express that through this. A lot of the problems in all of this result from the fact that you have voice which is mapped onto a person's face, and that is certainly a carve out, right? So in looking at these things and constraining them, I think it is prudent to look at exceptions in terms of these types of mappings, because I think it'll go a long way to providing the nuances around the legislation in terms of delineating what Senator Nethercott was expressing. And the second thing that I think is also very important is to realize that these things are, regarding AI, are not unrelated to the same challenges we have with the definition of smart contracts as it relates to artificial intelligence. Now, we had worked up a new definition of smart contracts, which is definitely needed. That's not, specific to this bill. These things do go hand in hand, and I urge the committee to, as we look forward, to look at developing these definitions concurrently. I do hope all of this is useful for the committee as we go forward.
Thank you, Brendan. Appreciate your testimony. Any questions for Mr. Marr? Any questions? Seeing none. Thank you, Brendan. All right, I believe we have Arlen Valdivia. All right.
Thank you, Mr. Chairman.
Please bring Arlen on. Arlen, welcome to the committee. Please state your name and who you're with, and the floor is yours.
Thank you. Good morning, committee members. My name is Arlen Valdivia. I'm a vice president of the State Government Affairs with the Motion Picture Association. On behalf of the MPA, we appreciate the thoughtful work that the committee has put into this draft legislation and continues to urge careful consideration of legislation in this rapidly evolving area. We acknowledge the legitimate concerns around the use of artificial intelligence and related technologies to harm individuals. However, the proposed legislation lacks concise definitions and would arguably impose labeling requirements for any audio and visual that has been altered through the use of digital technology. We oppose mandatory labeling for when expressive works includes the use of AI-generated material, which would hinder creative freedom and constitute a content-based restriction on speech. We have respectfully proposed amendments to Section H in our draft letter, which we submitted yesterday, to legislation to ensure that it does not constitutionally encroach upon the First Amendment, protected speech, and creative freedoms, including those of filmmakers, broadcasters, photographers, journalists, and others who employ new technologies to entertain and inform audiences. We further propose that the definition of synthetic media further clarify that the real natural person depicted in the audio or visual work be recognizable as such. Finally, the inclusion of a private right of action in the civil bill would invite costly and frivolous litigation against a broad spectrum of entities that distribute videos and voice recordings and who are likely to have had no role in the creation of the allegedly misleading material, especially those in news business that could be particularly vulnerable to lawsuits. We appreciate the work that you're doing. We acknowledge that this is a hard issue, and we thank you for the opportunity to provide our comments today, and we look forward to working with the committee on this issue.
Thank you, Ms. Valdivia. Any questions from Ms. Valdivia? Any questions, Mr. Co-Chairman? Go ahead.
Thank you, Ms. Valdivia. just to make sure I'm understanding you correctly, you're saying that at least part of your concerns is the censorship component of, and censorship of some of your members. Is that correct?
Go ahead, Ms. Valdivia.
Yes, thank you, Chairman. I think we want to just reinforce that there's clear exemptions for protected works because there is a private action clause in there. So, we feel the definition of synthetic media is broad, so we want to make sure that our protected works of our member companies are protected.
Mr. Chairman,
Go
to
ahead.
follow up, so again, it's the concern about state censorship of the work of your members. Is that, am I understanding that correctly?
Ms. Valdivia? Thank you.
So, Mr. Chairman, follow. Many of your members are subjected to state sponsorship from China and their input on the work that your members do. Don't you think that there's some kind of parallel there in terms of censorship, if that's your concern?
Ms. Valdivia?
I will acknowledge that I probably will have to follow up with the committee on that.
Thank you. Go ahead, Mr. Co-Chairman.
Mr. Chairman, no further questions.
Thank you. Any further questions for Ms. Valdivia? And Ms. Valdivia, we did get your email, so we have the proposed language. I do have a question about that language, though. While the synthetic media definition is, as you know, broad and would be relatively inclusive of a lot of works of your members, the real heart of the bill is the idea of the unlawful dissemination of misleading synthetic media. So it has to be specifically misleading. The misleading or the dissemination of that synthetic media has to meet the knowingly and intentionally standard, and you have to know that it's synthetic media. Do your members currently participate in that type of activity where they know they're disseminating false and misleading information? Is that something that the Motion Picture Association currently conducts and needs to protect? Or I guess I'm failing to understand the concern.
I think the concern that we have is for the member companies that have broadcasting and journalists that then will have to share information via their broadcast or their reporting.
Okay. Then a follow-up on that, Ms. Valdivia. So do those broadcasters know that they're misleading the public when they're providing that information?
If they're reporting on a news that was sent to them or a video that was sent to them, they probably wouldn't be knowingly, but we want to make sure that those broadcasters are protected as well.
I guess I'm just saying, wouldn't that protect them? If they don't know it, there's no possibility of them engaging in unlawful dissemination of misleading synthetic media, because that's the standard. They have to basically be complicit in it. But if they were, right, if they knew that it was false and they were standing up there, it's literally the exact intent of the legislation. But that bright line is, do they know what they're doing when they're doing it? That seems like the standard that you really would like, and I don't understand why that's sufficient.
The intent for the malicious intent we would want to keep, because that's not what our broadcasters participate in.
Okay, excellent. Thank you very much. Any further questions for Ms. Valdivia? Seeing none, thank you for your time. Thank you for being here.
Thank you.
Any further public testimony online? Any further public testimony in the room? Seeing none, public testimony is closed. Back to the committee. Committee, what's your pleasure?
Mr. Chairman, move the bill.
Got a motion? Is there a second? We have a motion. Is there a second? Second. Got a motion and a second. All right. Discussion on the bill to begin with, if there's any, and then we can go through and look for amendments. Anyone want to make any statements prior to going through? Mr. Co-Chairman?
Thank you, Mr. Co-Chairman. I certainly appreciate a lot of the discussion we had. I mean, the First Amendment is incredibly important, right? But I think our job ultimately is to solve problems here, and there's a problem that exists and is only going to get worse, that it impacts the people up here on this dais and the people we represent. And I think that there is a way to thread the needle on this particular piece of legislation. We talked about the time, place, and manner restrictions in the First Amendment. And I think that we can do so in a way that ensures people have the right to express themselves. I mean, again, the analogy I talked about where, the Chairwoman of Appropriations talked about different types of expression, commercial, political, et cetera. We already have some of those those restrictions on that political expression, right? Again, you have to put paid for. To your point, do I have an absolute right to infringe upon your privacy? Those kind of things. And so that's why I think that, well, I think there's some amendments coming that will probably improve it. I think moving this bill forward out of committee is probably the best course of action, Mr. Co-Chair.
Thank you, Mr. Co-Chairman. Representative Andrew.
Thank you, Mr. Chairman. It's too late to do something about it now, but I think I think bringing criminal law into the realm of free speech goes down a dangerous path. I think that is what torts are for. I mean, defamation and libel are codified in Title I of our statutes, and I think maybe a better way to have gone about this before, and maybe we can do this in the future, a private bill, a next interim, is to codify some of the other possible tort remedies, such as false light and appropriation of name and likeness, just so that people are more aware of those remedies. I do think that they will come, I think this is going to become way more relevant. But, I mean, even, I think one of the important things to consider is something we've talked about, such as the different types of speech: commercial, political, private speech. And, courts are willing to be a little bit more strict on commercial and political speech relating to elections, but we don't touch private speech. Even the example of yelling fire in a theater, I believe, is from a court case that, it was a dictum in a court case that was overturned. It wasn't even it wasn't a binding statement. And I think it's really important to protect free speech, in that manner. And there's a lot that concerns me. I mean, I thought I was for this originally. Someone sent me a video a while back, and it was a video of Ron DeSantis explaining how he only ate spaghetti and nothing else for 2 years. And
It's all true.
how
You heard it here first.
that negatively affected his health. And, what gave it away is that he didn't usually wear his hair in the particular style that he was wearing in the video. But if someone didn't know that about Ron DeSantis, could they be misled? And in this bill, could someone only eating spaghetti for 2 years and affecting their health be something that may have influenced someone's vote in an election? There wasn't also a notice in that video. I mean, who are we going to land in jail for something that they just created to be funny and entertaining on the internet? I think that's not the intention of this at all, but I'm just worried about how someone could get wrapped up in it in the future. Thank you, Mr. Chairman.
Thank you, Representative Andrew. Appreciate it. Any further discussion before we work the bill? All right. Go ahead, Representative Yin.
Thank you, Mr. Chairman. So I hear the free speech concerns, and I think that there are concerns that I have with the bill for sure, which is, I am going to propose an amendment, especially on the end of the bill. But I do think it's important to make sure that when someone is essentially using your identity to make you sound or say something that you actually didn't say, that it's important that people understand that it isn't you actually doing it. So there are plenty of political cartoons, for example, that, use my likeness in a cartoon fashion and make it say an exaggerated position that, from my perspective, is absolutely misleading, but is still a free speech right to put me in a political cartoon and say it's, say a position that, I don't think I necessarily have, but they have the right to say it, and make people think that I take a position that I don't. And do I think that's a good thing? No, I don't think that's a good thing, but I do think that it's their First Amendment right to do so. So I guess on balance, it's trying to figure out where that line is, right? So when it comes to political advertisements, right, we have disclosure laws, and I think that's important to make sure we know who is saying things for those sorts of things. And I do think it's useful to have that disclosure when it comes to synthetic media, to make sure people know that it is something that's made up, right? Just like a political cartoon is made up, and not actual factual video of a person saying a thing. But I do think that trying to thread that balance is really important. So happy to keep moving with the bill, but I think we need to still keep working on it.
Thank you, Representative. All right, let's go ahead and work the bill, do some amendments. Oh, go ahead, Mr. Co-Chairman.
Mr. Co-Chairman, so if we go on page 2, lines 22 through 23, the way it currently reads is synthetic media means an image, audio record, or video record of a natural person's appearance, speech, or conduct that has been intentionally manipulated or generated with the use of generative adversarial network techniques or other digital technology. I think this is, quite frankly, just unnecessarily and verbose, so my amendment is to strike with on line 22 all the way through to the word technology on line 23. So it will read synthetic media, or media means an image, audio record, or video record of a natural person's appearance, speech, or conduct that has been intentionally manipulated or generated in a manner to create a realistic but false image, audio, or video, or other representation that the reasonable person, et cetera, et cetera. So that's how it will read, and that's my motion for an amendment.
We have a motion, is there a second? Got a motion and a second, and I'd note that that specific language was from another bill that was passed. I believe it may have been from Washington's bill. It is oddly specific with generative adversarial network techniques, which is a specific application of AI, and then or other digital technology, which broadens it to everything. So it's simultaneously overly specific and then entirely general. So I agree, it really doesn't serve much purpose. Any discussion? Seeing none, all those in favor say aye.
Aye.
Opposed, no. Motion carries. Any other amendments?
Mr. Chairman,
Yep.
I have an amendment on page 3
Okay.
to strike lines 9 through 22. This is the part that requires someone generating this content to put a notice within their content. I think this is overly burdensome regulation, and I think it's actually, to me, probably the most offensive part of this bill, because what it does is it compels speech. I don't believe it's the same as, saying paid for by on a campaign notice. The courts treat campaign speech differently than private speech. And this part of the bill would compel private speech.
Is there a second? Is there a second? There's a motion and a second. Motion by Representative Andrews, second by Representative Singh. Discussion?
Mr. Co-Chairman,
Senator Nethercott.
I think that by striking that language, you make the bill unconstitutional. And so I think it's a very important provision. In one area that I would encourage you to think of that Co-Chairman Western mentioned, which is the disclaimer for political speech when we require paid for by language. Similarly with commercial speech, right? Think of all of the FDA products, right? That are all the products that are advertised late night to make all of our lives so much better, and how all of that commercial speech really can push the bounds of speech, and yet we still have laws regulating that to make sure the public isn't misled that the product they're buying really won't make them 4 inches taller. Watch those commercials. So, so we do require, this is a paid, advertisement. We require that as part of making sure the public has protections associated with communications being made by business. So I don't see this any, there are distinctions certainly, but I see this in a similar fashion.
Thank you, Senator. Discussion, go ahead, Mr. Co-Chairman, and then back to you, Representative Andrew.
Thank you, Mr. Co-Chairman. I certainly agree with the good chair that you're taking at the one option that allows this type of behavior as part of this expression. So if we pass this amendment, then you're simply saying that this behavior is just not permissible, period, which, to your point of constitutional concerns, I think it really puts it deep in the unconstitutional territory. But I think you talked about the right of private expression, private First Amendment rights, but kind of building on your example of a video of Ron DeSantis talking about how much he loves spaghetti, if that message, if you make this deep fake, it goes viral, millions of people see it, does it transition all of a sudden from private expression into political expression, given the nature of the video, the content, and the reach that it has achieved in viewership? So I think that's just another consideration to think about, and having the one thing that ensures, hey, this is parody, this is some type of disclaimer, removing that component guts the bill.
Thank you. Representative Andrew.
Mr. Chairman, I think we need to recognize that commercial speech is treated differently by the courts. In fact, we've recognized it multiple times over the course of our conversation. And this section that we're trying to remove also applies to private speech. I don't know in any other situation, that anyone has been required and compelled by law to disclaim a point that they're trying to make. And that's what this does, because it doesn't only apply to commercial speech. It doesn't only apply to political speech. It can apply to everything. And removing this section doesn't actually, unless I could be misunderstanding the flow of this here, but it wouldn't make any of this unlawful. What it does is, under section B, this part would apply to, the other remaining Romanettes that follow. So I believe we are just taking out the requirements to have that disclaimer in there.
So with the structure, it's there so that if you want to create what would otherwise be deemed a deep fake, so it's achieving all of the other aspects, if you put a disclaimer on it, that's your get out of this act free card. Removing that says, even if you put a disclaimer, you don't have a get out of this act free card. So the disclaimer goes in the opposite direction that I think anybody that wants to increase the availability of rights or removing the disclaimer goes in the opposite direction that I think you would want, Representative Andrew. Because again, it provides an opportunity for any type of expression to take place as long as you note that it is synthetic media. Which again, I understand. We do it all the time for commercial speech. We do it all the time for political speech. We may be able to come up with one for individual speech. I don't have one off the top of my head. It's a good point. But it does provide a conduit to provide any expression you want. And at that point, it is not the unlawful dissemination of misleading synthetic media, because you have provided a little disclaimer that says synthetic media, which then makes it lawful. In other words, I don't think it goes the way you want it to go. Mr. Pope.
Mr. Chairman, thank you. I see that section as not compelling speech. It gives you an option, as opposed to that, then it's protecting your speech, your ability to say that. So you can choose to continue to mislead people, or you can choose to provide a disclaimer. It's not compelling you to do either.
Absolutely. And the other thing that it does, we talked about in the working group, is if you do have a social media platform, for example, and there is generated synthetic media and the platform finds out that it's synthetic media, they can just put a tag over it and they can continue the post instead of having to take it down. It provides more access through that. Go ahead, Representative Andrew.
Mr. Chairman, I think maybe, and without malintent, but what this section is trying to do is provide an unnecessary alternative to the First Amendment then.
Unnecessary. Representative Andrew, I don't know that I agree with that. I think it's trying to provide as much access to providing whatever content and speech you want without it being misleading. That's the key concept. Again, the crime is not necessarily the synthetic media. The crime is the unlawful dissemination of misleading synthetic media. That's where it comes down to. You have to be misleading. That stops it from being misleading and is an easy way out of it being misleading synthetic media. Kind of like imagine libel or slander laws. If you included a little disclaimer that said everything I just wrote isn't true, that might potentially get you off the hook. I don't know that that's actually in the statute, but it's that type of concept. We just made all of that up. It is an important way to not be misleading. So it provides clarity that the act would not be applicable if you had a disclaimer. All right, any further discussion on this motion? Seeing none, all those in favor of the motion say aye.
Aye.
Those opposed, no. No. That motion has failed. Further amendments? Okay, Representative Ian, go ahead.
Mr. Chairman, I have a motion on page 6. I sent it via email to everyone, but I'll read it out for the public just so the public knows what the motion is. It is to delete on page 6, which is the end of the bill, lines 6 through 9, and replace it with the following language. Subsection H, this section does not apply to any of the following, Romanet 1, a distribution platform. If the distribution platform has a clearly stated written policy provided to any person that any synthetic media must include a statement consistent with subsection B, which is the part that lists out the disclosure requirement. Romanet 2, synthetic media that consists of parody or satire. And Romanet 3, any synthetic media protected under the First Amendment to the United States Constitution or Article 1, Section 20 of the Wyoming Constitution. So that's taking the existing language from subsection H and then just restructuring it with a list of essentially exemptions. And so that's my motion, and I'll add some more discussion if there's a second.
We have a motion. Is there a second?
Second.
We have a motion and a second. Discussion.
So, Mr. Chairman, thank you. In my head, it's always trying to think of, I know what the problem we're trying to solve, but are there examples that we would actually block by having the bill's language as is, and then trying to figure out how do we adjust our language a little bit to make sure that we're not blocking things that should be protected. And I understand the chairman's goal of having both the First Amendment exception being broad enough to theoretically capture all the things that it's supposed to capture, and also that intent to mislead to protect all the people who are not intending to mislead people. But I do think that there are risks there with that language where people will still propose lawsuits saying that someone is intending to mislead, and then you have to go through the lawsuit channel to end up with the case where you do end up proving that you weren't intending to mislead. And I want to kind of stop that right at the beginning, especially when when it is in regards to political speech, where we are talking about, right, so you could have a Photoshop of myself, a photo of me, and the background is like a nuclear explosion saying, and then there could be like text under it that says, Mike Yin loves throwing around nuclear bombs, or something ridiculous. I think that would fall under the definition of synthetic media under our statutory definition in the bill. And so I think that is fairly satirical. So I do think that that at the very least, we need to have a structure where we can start making sure we don't block things that we shouldn't be blocking. And then the distribution platform, I think, is just useful to make it clear to distribution platforms that the liability should fall under the content creator, not necessarily the distribution platform. There could be some wiggle room there, and so I'm open to amendments in that language, but I think that's broadly my intent of the amendment.
Thank you, Representative. Any discussion?
Mr. Co-Chair,
Go ahead.
I'm struggling with understanding the fixation with parody and satire as opposed to other forms of speech, and why we're carving that out. I mean, I understand that that's an easy form of communication that frequently is done in the political space, that, you know, we've all seen SNL. We're in a committee meeting, so we can actually use proper names, you know, where they have actors that are intended to portray politicians, and they put on skits of satire and parody. And that's what I think all of our minds are going to. And we want to make sure that type of speech is protected, right? And that type of behavior is allowed to continue. We're not trying to address that. So I just, in my mind, I'm like, what is this obsession with that particular type as opposed to regular drama, right? To other types of ways that humans communicate, other than parody and satire, and expressly stating that, which is a very subjective, actually, medium of human communication, I think is a dangerous thing. So I propose a friendly amendment, perhaps, to strike that section of the proposed amendment, which I think is Romanet 2 in the proposed amendment.
Representative Yin?
Mr. Chairman, I'll make it friendly. I'll say it's friendly.
Okay, and just a quick point on that also. It's important to look at the definition of synthetic media.
Yep.
And it's honestly important to look at all the words of the legislation and not just the discussion, but look at the actual words on paper. Synthetic media requires that, as you see at the bottom of page 2 on to page 3, that a reasonable person would believe that the appearance, action, or speech occurred. This has to be believed to be true. Our traditional parody or satire, I've never believed anything I've seen on Saturday Night Live.
Mr. Chairman,
I've
speak for
enjoyed
yourself.
it, but yeah, well, all right, fine. Depends on the reasonable person we're pointing to.
And Mr. Co-Chairman, if I may, similar to that, I think Representative Yin brought up a good point, which is, can I put your photo and place it somewhere else? And is that, you know, the example that Representative Yin provided was in front of a nuclear bomb. You know, in that example, no reasonable person thinks Representative Yin is standing in front of a nuclear bomb watching it explode. But I get the point, which is, does this bill address someone duplicating my image and placing it in some other location? And then suggesting something, right? So.
Yes, if fully realistic and a reasonable person would believe that that person was there and that happened, that would meet synthetic media.
Back to my amendment, if it's friendly.
Yeah.
Representative Yin thought it was friendly, so that amendment has passed, correct? Because
Your
the-
friendly amendment is passed. Romanet
Just
2.
for clarity for the committee.
Yep.
Mr.
Go
Chair,
ahead, Mr. Co-Chairman.
Again, I think it really comes back to your point and what we talk about on page 3 in Romanet B about knowingly and intentionally. The case that Representative Ian talked about, I mean, I think we're getting in meme land there. The entire meme world, I am unaware of anybody that makes memes that does it to pass off as news or deliberate actions that actually happen versus just someone making hilarious memes of elected officials or otherwise. So I think that squarely falls into protections we currently have. And I think this is a situation where it really comes down to the specific example we're talking about here. Mr. Co-Chair.
Thank you. Additional discussion, anything on Romanet 1? We'll go to Mr. Pope and then we'll go to Representative Ian.
Thank you, Mr. Chairman. A couple of things. I believe lines 6 through 9 accomplish almost everything that the proposed amendment accomplishes, and I think it leaves it. I think it's a simple statement that anything under the First Amendment is not deemed to violate the statute. My second thought is, if you adopt this amendment, Romanet I is troublesome to me because it just specifically states that the distribution platform has to have a policy. It speaks nothing to enforcement of the policy. I believe the policy, there needs to be reasonable attempts to enforce the policy. Otherwise, the distribution platform should be accountable as well. I look at this, I'm an accountant, and I usually poke a little fun at myself for being an accountant, but really I'm very, very proud of the fact that I'm an accountant and a CPA and all of that. My reputation is my life. It's my career, it's my livelihood. And if there is something that is intentionally false, created in this manner out there, I want as direct a route to a remedy as possible. This bill provides a direct route, and to give a broad exemption against anyone who aided and abetted in that process, I'm against. And that path has to be there for someone like me, or really any average person who isn't involved in the political process and who is just devastated by something like this. So I understand Representative Ian's point of view on this, but I am quite a bit more hardline on it. I want a path even to a distribution platform if they've aided and abetted in this. Thank you.
Thank you, Mr. Pope. Representative Ian.
Mr. Chairman, thank you. So just to reiterate, right now, without the parody and satire part of the amendment, it is just a restructuring of subsection H to be a list of exemptions, where the main one is just the First Amendment exemption, that broad First Amendment exemption, and then an exemption for a distribution platform, as long as they require any content to be to have the disclosure that we require. I think that if it is in their requirements, that they should be enforcing their requirements. So I do think that's something that a distribution platform should do, but I'm unwilling to put liability for the platform within the bill. So I'm still going to leave the amendment as is, as amended with friendly amendment, but happy to discuss further if the bill moves on.
Mr. Chairman.
Yep. Go ahead.
If I might just seek a little bit of clarification on the amendment. Is the intent with the subsection B, because that refers both to the notice requirement and to with the intent to mislead requirement, is the intent to include both of those be provided in some sort of notice, so that the notice might say something along the lines of you can disseminate, or you need to provide notice if you're disseminating misleading synthetic media? I mean, I don't have issue with that per se, but I just wanted to make sure it was intended that it applied to both of those paragraphs.
Representative Yin?
Mr. Chairman, I think that is the intent, yes.
Further discussion? So I have concern on the Romanet 1, and my concern goes back to the fact that I don't see why we give preferential treatment to a distribution platform. If they meet the B provision that they are engaging in unlawful dissemination of misleading synthetic media, when they knowingly and intentionally disseminate synthetic media, knowing it to be synthetic media without clear distinction, if they've done all of that, they've done something wrong, and they know not to do all of that because it's clear. There's nothing special about a particular company based on what their business is. This is crafted in a way that either you're doing this and that's bad, or you're not doing this and that's not a problem. It would definitely provide them with the ability to add their own clear and conspicuous visual designation, and at that point, they can continue to post anything they want. That would be their obligation. The concern I have with having the written statement is, first of all, it assumes it's read, which we all know how many people read those statements, but let's assume they did. The bad actor is probably not going to have their own name, the original creator. They're not going to post it under their own account as this is misleading synthetic data. They're going to rely on it going viral. When it goes viral, it literally makes money for the enterprise that's hosting it. It's their whole purpose. So they're making money off of a misleading, unlawful dissemination of misleading synthetic media. I don't know why we would give preferential treatment to the platform, a distribution platform, once it becomes complicit. And before it becomes complicit, it hasn't done anything wrong. So I have a concern about carving out, and there are carve-outs in other statutes, so it's not that hasn't been done before. So the other states that have looked at this have moved towards carve-outs, but I would have concerns saying that it's okay for the distribution platform as long as they had a policy that said you shouldn't do it. Any further discussion before we take a vote? Go with Representative Singh and then Representative Andrew.
Thank you, Mr. Chairman. I am concerned about nuances in particular behaviors that may be demonstrated with an algorithm. Let's say that for some reason 10 years from now that I happen to have a dispute with a particular colleague, which happens, right? But someone were to, and that were a powerful point that I was intentionally trying to make as a platform for my campaign. And then someone came and created an artificially generated photograph of me shaking their hand when I had very, very clearly not shaken their hand in the positive sense. And so I don't necessarily think that this bill interprets both ways, because we can inflict a positive connotation when a negative connotation was intended. And I don't think this bill adequately covers that.
Is that on the amendment specifically or back on the bill? Oh, no worries. No worries, Representative Singh. I just wanted to understand if that was a concern with the amendment. Appreciate the thoughts. Representative Andrew, on the amendment?
Mr. Chairman, I was also off track. I have more on the bill.
All right. Any further discussion on the amendment?
Question.
Seeing none, question called. All those in favor of Representative Yin's amendment, say aye. All those opposed, no.
No.
That motion has failed. Back on the bill, any additional amendments? Any additional amendments? One that I will offer, but I won't make the motion. Oh, go ahead, Representative Andrew.
Thank you, Mr. Chairman. So I have an amendment to page 4, line 5, which would be to strike the words bot, or I guess, or person who is misled by. And what this would do is basically, it would put the person who really is the victim of this, the person who was depicted unlawfully, it would be, the responsibility would be on that person to pursue this or not, and not just anybody who was misled. We all know probably all kinds of people who believe all kinds of stuff on social media, and it's really easy for people to be misled, even if you don't intend to do it. And there's all kinds of things to establish here and definitions and all that we can bring into this. But with reference to no one in particular, I would consider being misled online to be kind of a personal problem,
What would it mean?
and not something that you can just pursue legal action against someone for.
Thank you, Representative Andrew. We have a motion. We have a motion and a second. Is there discussion? So go ahead, Mr. Co-Chairman.
Mr. Chairman, on the amendment, so I know the amendment is to strike "or who is misled." Is that, Representative Andrew, am I understanding that correctly?
And whichever by you want to get rid of. but
And to
yeah.
buy. Yeah, exactly.
Got to get rid of buying there. And this is a question, I think, to the committee broadly, to our attorney, our gracious in-house attorney. If we put materially in there as a potential friendly or unfriendly amendment, what are the implications of that?
Ahead of misled.
Yeah, ahead of misled. So it would see, or who is materially misled.
Raising the bar.
What kind of additional standard would that place in terms of, proving that in a court of law?
Mr. Coffin doesn't. Mr. Coffin doesn't love it.
But we
I can see
like
that.
Because I always have the first.
You're not as expensive as he is.
Mr. Coffin, thoughts?
Mr. Chairman, I was saving my comments for the end on the bill in general, but that's getting at one of my ultimate, and again, let me say, I'm a huge fan of this concept, but we are literally hinging everything on this bill down to the intent to mislead. That is completely subjective. So whether we add material to that or not, frankly, I just think that complicates the subjectivity of that analysis, right? I mean, we're literally saying this is all illegal unless it's constitutional, right? This is really, really subjective in terms of hinging it on that materiality or hinging it on the misleading. So yeah, I'm a huge fan of this concept, but the more I think about this bill, the more a disaster I think it is to try to enforce. So I would caution against that.
Mr. Co-Chair?
Go ahead, Senator.
So the language that it is on intent to mislead, right? And those few words aren't disregarded. So the constitutionality of the bill does hinge on that, and other protections is found in the bill. The other language that is commonly used in the law, and Daza brought up, was reckless disregard for falsity. That is a lower standard, but do you feel better about the sophistication of the language, right? I mean, intent to mislead generally requires a specific intent. Reckless is lower than a specific intent in the law. And so some of these words have more legal meaning than perhaps this committee may be considering in this moment. But I think to step back from this bill, as most of the bills that we review and vote on, have constitutional considerations. This one is more obvious. The question is this bill as drafted unconstitutional? Only a court can make that determination. We cannot. But recognizing our concerns for free speech and not wanting to chill speech, I think a good question to ask ourselves, does this bill chill speech? And, that's a question. Does the bill chill speech? And particularly with the protections of requirements of a disclaimer. Is the speech still chilled, or is it, that's the question. Does this bill draft chill speech? And that's the opinions that matter here, because there are legal protections placed within the bill in order to make it constitutional. Does it limit a First Amendment right? Maybe. For example, let's say we have two regular people, one who creates a false, who uses this technology to harass another, right, publicly on social media. And they are literally, they're just harassing that person. And they get charged with harassment. Is that person's First Amendment right violated, and they can now sue the police or sue that other person? Is it legal to stalk and harass somebody? No, it's not. So there are reasonableness associated with the application of these laws all the time, right? And so this is a scary bill to move forward. It is scary in that regard, in that a court could declare it in its particular application, of which we haven't fully appreciated in our deliberative debates and public comment, that could infringe on someone's free speech rights. It has that potential, but I do think that we have provided appropriate safeguards to ensure its constitutionality. But in your opinions, if you find that it goes too far to chill speech, then vote no.
Thank you, Senator. We're on the amendment.
Whatever.
But no,
Whatever, Mr.
it
Chairman.
applies. I thought that was relevant to the amendment. I'm just noting that we're on the proposed
Question on
amendment.
the amendment?
I think more discussion on the amendment. Any further discussion on the amendment? Mr. Pope?
Thank you, Mr. Chairman. Really quickly, the courts adjudicate materiality all the time, and materiality and intent all the time. I don't believe that. I think adding that may enhance. Adding that term may enhance the bill, and I wouldn't be afraid of having that word in there. I think it does set a little bit higher of a bar, but I'm an accountant.
So another alternative, which would raise the bar even further incidentally, is it could be "or who is misled and harmed by." So you actually have to demonstrate a harm. Senator Endicott doesn't like that one. Mr. Kaufman seems to maybe.
Mr. Chairman, I think that's one of the complexities of this that has to be considered, right? The entire case law defamation is built upon that premise, right? There's defamation per se, right? There's certain things you can say about someone that are in and of themselves deemed to be harmful, but most other instances, unless it's a criminal context, right? Like you're threatening someone or you're saying something that is actually a crime, there is a harm element to that. And I don't think that can be overlooked or glossed over in this context, because I'm very sympathetic to what Mr. Pope was talking about a minute ago when he's talking about having the private right of action, which is, again, another component we haven't even talked about, how to synthesize that with other like rights, of private action with respect to your likeness, your personhood, your, copyrightable material, whatever it is. And so we're taking a whole nother step in this context that is a very slippery slope. Sorry. Thanks, Mr. Chairman.
Thank you. Senator Endicott? No? Mr. Co-Chairman?
Thank you, Mr. Co-Chairman. Mr. Kaufman, maybe I agree, right? You can't just say my feelings were hurt. It was, you have to be able to prove damages. And I'll yield to your expertise, but my own impression was that because of the way our libel statutes are written, it's very tight in terms of what is acceptable in court. But that's obviously in a private incident, which this bill, of course, could potentially cover. But wouldn't it be much different than in some of the examples that we've cited here when it comes to political speech? Do you use that kind of an apples and oranges, or?
Yeah,
Kaufman, go ahead.
Mr. Chairman, again, I'm not an expert on defamation, but in the private context, right, what we have a body of case law in this country that has established that if I'm going to institute a right of private action for defamation against you, to prove that harm, there are different thresholds, right? And if I'm a public figure, that threshold for harm is incredibly heightened, right? Because I'm already in the public realm. People can say things about me, right? Courts have made exceptions for things like parody and satire to say, well, that's right. Political speech, right? We're debating ideas, right? If I'm imputing what you're saying because I disagree with you, that's not necessarily an attack on you that would evidence harm, right? So these are all the various factors that courts have to look at to determine, is this harmful, right? And as such, is it quote unquote illegal, right? Does it grant me a remedy? And so all I'm raising here is that is one discussion with a whole host of constitutional law and considerations. And we're sort of jumping over that to say, oh yeah, if you intend to do harm and it's misleading, it's illegal, right? And now we're putting that in the hands of a prosecutor to make that judgment and go. And your only defense is it's constitutional, right? Of course, that's the debate. So to me, we're sort of skipping over and we're applying what looks like a private right of remedy, right? And putting that in the hands of a prosecutor to enforce this, is it or isn't?
We can take the criminal out.
Well, I think that's the teeth of this bill, right? And again, what I was advocating for a moment ago, and very much appreciate the comments we heard from others about the ways the private right of action might be muddy, and create more mess with respect to how this is interpreted or enforced from state to state. And does it keep people from wanting to do business in Wyoming because now we've created this extra private right of action? I don't know, maybe, maybe not. But if it's defamatory, we already have causes of action for that.
But we don't.
We do, right? I mean, you can bring a private right of action for defamation anytime, whether it's synthetic media, and we've defined that or not.
That gets to the depicted person, and this kind of gets to the root of the motion, which is to take out those who are misled. Most of the harm from synthetic media that we'll see is probably not going to be to the person that was imitated through synthetic media. It's the intent of it is to change outcomes, and that aspect of being misled, there's nothing there. What is anyone going to hang their hat on to when they are significantly misled? The misinformation is allowed to propagate. The public consumes it, believes that to be true. You don't even know who produced the image in the first place, typically. That's the real challenge here. Well, that's one of the real challenges. The other side is the individual, if they want to have that protection. But in all likelihood, most of the time, things that might be of the most concern, the person won't be in Wyoming and certainly wouldn't be taking an action in Wyoming. But many Wyomingites will have been misled through, think about concepts that we do have. We have identity theft. We have libel and slander. Defamation, you say we don't have.
Well, we do.
Yeah, I know, but it's just weak, effectively. Does anyone here actually believe that a sophisticated deep fake that of a political, high-level politician, whether it was in their favor or against them, if that took place in Wyoming, would anyone have any legal recourse? I can't imagine anyone would bring anything, or it would be immediately dismissed. Mr. Kaufman, do you think there's any law that would in any way influence that?
I mean, Mr. Chairman, again, that's getting back to sort of the point I was trying to make a moment ago is maybe, right? I mean, there's a lot of avenues that someone could institute a private right of action under that. But I mean, do I know the answer to that question? No. And the outcome of that? No. Are there avenues and claims that one could make in that context? Absolutely, both federal and state. Do they stick? Does it work? Does it create the remedy? I mean, that's the onus of any person that has to go through the court proceeding to prove their damages or to prove the harm. And all I'm suggesting here is I'm in 100% agreement with you on that point, and that a person in that context should have a right. But defining what that is in this bill is all coming down to that intent to mislead. And we're putting that in the hands in this context of that constitutional analysis, right? Of is it constitutional or isn't it?
Well, at that point, it can be, I mean, if it goes to civil, it can be balanced effectively. If we take out the criminal, then that balance can take place in the eyes of a court where they're looking at the circumstances and they say, well, this is clearly parity, it's protected rights.
Well, Mr. Chairman,
Senator.
I mean, there's two challenges. I mean, this is incredibly legally complex. Incredibly legally complex. So, you know, typically when you're looking at a First Amendment violation, right, it has to be government action. So the government actually has to be the one to take action to deprive you of your right. So in this context, this bill could be unconstitutional on its face, right? In that we passed an unconstitutional bill and then some lawyers down in Denver get a lot of money. Or, you know, otherwise, the challenge here is what government actor in Wyoming is going to exercise discretion when applying this law. The AG, a district attorney, a county attorney, potentially, and they could be taking a First Amendment violation in the exercise or application of that. That would be the government action here. But what's unusual is this private right of action concerning a First Amendment protection, adding further layers of complication, which is why I think it's helpful to bifurcate these analyses out, which I don't think we've been able to do here. I mean, this would be a book for legal scholars to write on when First Amendment law is incredibly complex. You have a private right of action, you have advancing technology, you have a need to protect the public, right? So when we analyze the constitutionality of it concerning that government action, what type of standard would be applied, right? Rational basis, strict scrutiny, right? Intermediate. Well, the need to protect the public to ensure that they are participating in free and fair elections is certainly a valid rationale. I want that on the record. That is the reason why, one of the reasons why we're moving this forward is the concern over the public harm to protect the people, not necessarily a private right of action. The private right of action is the tool for which to hold accountability for reckless disregard for falsity.
Mr. Coppin?
Yeah, Mr. Chairman, just one more comment. I agree with what Senator Nethercott just said. And I'm very interested in protecting that private right of action, but I'm recognizing, right, that it's incredibly complicated to institute that here in a clean way that preserves that right. But getting back to, you know, my final comment, I kind of think all of this discussion is leading me, this is probably why some other states have focused on the political aspect, right? And it's more of a bite-sized approach to this as opposed to just opening it up to anyone, right? Because to your example, do I believe that's a threat to, right, our democratic process? Absolutely, right? If someone is intentionally disseminating some deep fake that is, you know, attempting to sway the outcome of an election or public perception of a public figure, absolutely. Should that probably lie in the hands of a prosecutor? Absolutely, right? But that is totally and completely different, as Senator Nethercott was just pointing out, than a private right of action and what goes along with that, and what are the elements, what are the damages, what are the ways, who are the parties that we're going to hold accountable for that. That's a very deep analysis with a lot of, you know, moving pieces. So that's the disconnect I'm personally struggling with still.
Thank you. Go ahead, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. On the amendment.
On the amendment.
On the amendment.
It's to strike on
It's
page
to strike
4.
or who is misled by on
Yeah.
page 4, line 5. Senator Nethercott? The thought here is, if I'm understanding the bringer, his intent is that, you know, it creates all these frivolous lawsuits, unnecessary litigation. The one scenario I don't think we've really discussed, and that relates specifically to this amendment, is in the affirmative, like preventing people against a negative action, against, you know, lying, deceit, in terms of, you know, the harm that may cause. But what if again, I really emphasize, I think this really comes down to the examples of the scenarios that which we are applying this. So what if we have a candidate running for office who creates a deepfake of them running into a burning house and saving lives, saving kittens, saving the kittens from the nuclear bombs?
Mike, yeah.
There we go. Point proven. That we are affirmatively, affecting someone's opinion in a positive way, when in fact that candidate actually did not go into that burning house and save those people. So I think in this kind of scenario, in this amendment, if I would not have voted for someone otherwise, and I'm materially impacted, is this taking away my ability to say, actually, candidate A or candidate B or whoever it is misled me, and I feel I want to exercise my right of private action? My understanding is that this, if we pass this amendment, it's taking that ability away from me. Is that correct, Mr. Co-Chairman?
Mr. Co-Chairman, yeah, that's correct. That's my understanding. It creates a rather significant loophole for that circumstance. Additional discussion on the amendment? Yeah, Mr. Chairman, I have the same concern about the amendment. I think that I understand the concerns, certainly, about intent to mislead. That is very clear. But taking this out simultaneously doesn't solve that problem and creates a host of different problems. So I don't think this amendment's helping. Further discussion on the amendment? Question on the amendment. All those in favor of the amendment, say aye. Those opposed, no.
No.
Sounds like it failed. Everyone agree? Okay. Additional amendments? Does it provide, oh, go ahead.
One
Representative-
more, I'm sorry.
No, go ahead. No worries, please.
Mr. Chairman, starting on page 5, line 21, and continuing through page 6 to line 4, this is the part of the bill that actually includes jail time. And with how much uncertainty and how much, I still think is unsettled with this bill, I think that for now we ought to remove it. I'm worried that we might not have enough room in the prisons for all the people that could get caught up in this. I'm worried about the guy who created the Ron DeSantis spaghetti video and all these other things. I just don't think at this time when we're so uncertain involving, jail time is appropriate.
That's the motion. Is there a second?
Excuse me, Mr. Chairman, real quick. Representative, could you repeat the amendment
Go ahead,
to delete
Representative
both,
Andrew.
all those? That's
Yes,
paragraph
Mr.
G?
Chairman. So page 5, line 21 through page 6, line 4.
Gotcha. Delete paragraph G, the misdemeanor offense. Okay. That's the motion. Is there a second? Is there a second? Motion dies for lack of second. Any further discussion, any further amendments? Seeing, go ahead,
Discussion on the bill.
discussion.
I mean, it's not my hope that, I'm going to vote aye on this bill. I do think it's important that the full legislature has an opportunity to continue to discuss this issue and get more eyes on this topic. It's not my hope that the bill fails in session, but I think, that this is one of those topics that may require a couple-year effort in order to really get our arms around the issues that we as a society are dealing with, identify more carefully and thoughtfully those ideals, particularly democratic ideals for a free and fair and open society that we're trying to protect, and which is our goal here, right? This is our goal. And how we more acutely narrow that down without infringing upon those freedoms, right? And so if the bill fails, and it may in this next session, I think that's okay. I'm not hoping for that, but I do think that's okay, and I look forward to debating it in the full session.
Thank you, Senator. Additional discussion? Mr. Kaufman.
Yeah, Mr. Chairman, thanks for letting me weigh in so much on this bill. I mean, I agree. While I'm concerned about the nuts and bolts of this bill and how it would actually be enforced, and of course, the constitutional implications, and still, further defining the private right of action and what that looks like. This is a hugely important topic, and this is evolving so quickly. But I do think, I think Wyoming needs to be a little careful about, right, jumping into something that we inadvertently, right, regulate out of the state, or discourage market participants from being in the state for something that's overly reactive, right, that it doesn't intend to be. So I would encourage in the short term the conversation to steer more towards the political context as we discussed, and circle back on and include sort of the more broad and the private right of action. I think that's just going to be tougher to define really tightly and cleanly, but I think it's incredibly important to maintain.
Thank you, Mr. Kaufman.
Mr. Co-Chairman,
Go ahead, Senator.
I share the same opinion as Mr. Kaufman, that I think it's prudent to limit it to the political context for now, as the greatest concern for society as we deal with these changing technology. And then with more time, a larger perhaps, protection or a larger coverage. But I think that's a prudent and cautionary approach. So consider that.
Thank you. Go to Mr. Pope and then Representative Yen.
Thank you, Mr. Chairman. Confining it to political, the political process doesn't protect me, doesn't protect the average person. And when I look at this bill, I see a direct path toward me being able to protect my own interests and my own reputation, my own future. Whereas if it's confined to the political spectrum, that doesn't apply to me whatsoever. So I am hoping that this passes in much the same way it's written now. Personally, if the criminal aspect were taken out of it, that wouldn't matter to me, because when you look at the way the AG's office in the court or in the prosecutors choose cases that they are going to take to court, it is based on a lot of different factors, and this gives me the ability to directly address the whole situation. Yes, very complex. I understand Mr. Kaufman and Senator Nethercott's concerns over it, but if we are only going to protect folks in the political spectrum, that doesn't do a whole lot for people like me and the other 600,000 people in the state of Wyoming.
Thank you. Go ahead, Senator.
Thank you. I do think it's important to recognize there's a private right of action, and so we apply that to ourselves and imagine our own images being utilized. I think what's important to understand, this bill is intending to protect the integrity of information being provided to the public to make, I think for Mr. Kaufman and I's concerns, fully informed and educated and accurately informed decisions about candidates to vote for, not necessarily protecting my reputation. We all know how that's gone. So really, though, it's more about ensuring that people are deterred from, providing images of a presidential candidate, for example. Those are the ones that are most harmful, sitting at a table with Putin and, planning on doing something terrible. I mean, something really egregious, right, that the people believe and causes an outcome. We want to discourage that, not necessarily creating a bill that only protects the politicians and ourselves, but to preserve the integrity of our democracy by reducing the amount of, or the reducing and recognizing the danger of this technology, separate and apart from what we're used to seeing, which is, political opponents attacking each other in lines that seem pretty close to slander or defamatory, right? It wasn't accurate that I ever voted to give myself a raise. But certainly those were statements that were expressly stated. It was false that I was being sued for lying. That wasn't a true statement. Is that First Amendment speech, right? Do I have a private right of action? All those pieces. No, that's not what we're really trying to protect here. We're trying to ensure that the public isn't so misled to engineer an outcome potentially by our adversaries, right? That to me is the purpose of this.
Yeah, agreed. Go ahead, Representative Singh.
Thank you, Mr. Chairman, and Senator, I respect what you've just said. But all of these accusations that were just made against you, which are false, were done intentionally, not by artificial intelligence, but by actual intelligence. So I don't know if this bill would actually cover that.
Oh, it doesn't require it to be AI. That's the kind of the purview of the topic and what is bringing it forward. But particularly with taking out the cause, it's humans in charge of this. Certainly no requirement for AI to be involved. But I don't think the bill would cover Senator Nethercott based on the fact that it would have to have been a recording of audio of her saying something or video of her doing or saying something in that circumstance. So this wouldn't cover from that standpoint. Representative Singh?
I received that, Mr. Chairman. My apologies.
No worries, no worries. And I believe that I skipped Representative Yin a moment ago. He had his hand up and I jumped to co-chairman, I think.
Mr. Chairman, thank you. I mean, I think the bill is salvageable. I think the concept is sound. It's the execution that is super important. I do think that there's a real risk of maybe every distribution platform just geofencing out Wyoming. And could that be a good thing? I mean, maybe in some ways that could. But
Yeah, what did you describe there? Is that a risk?
So I think we'll have to see how this plays during the session. So again, I'll vote to move it forward today because I do think the concept is sound, but I do think that it will require work during the session.
Thank you, Representative Yin. For the discussion, we'll go to Mr. Kaufman and then Mr. Co-Chairman.
Mr. Chairman, just one very last comment that just popped into my head, but that is, and maybe somebody knows, this bill is silent with respect to the statute of limitations. And I know that defamation and fraud, I think, both have 1 year statute of limitation in one. Is that right? But then when you talk like about the Federal Copyright Act, they intentionally extend the statute of limitations to 3 years for things like that. So I would encourage the committee to think about that because I do think a statute of limitations would be important here.
Mr. Co-Chairman, there's a provision in Title I that says whenever the statute doesn't particularly identify, it defaults, I think, to 4 years.
Good. So that's what it would be by default. And I don't know if there's anything needed for more or
Mr.
less than that.
Hopkinson?
Mr.
Mr.
Chairman,
Hopkinson.
while that would be true for the civil side, the criminal law does not have any statute of limitations.
We're not going to change
Potentially, a
that.
criminal charge could
Helpful.
be brought later.
Senator Nethercott, get on that. All right, thanks. Any further discussion, Mr. Co-Chairman? Last thoughts?
Thank you, Mr. Co-Chairman, since we're all
Ready to
hesitating
go on break?
hesitating to opine. I mean, I appreciate the lawyering going on here, but at the end of the day, I think we have a problem. And it's our job to try to fix it. I think I think the good minority floor leader said it's not perfect and there's room for improvement. I wholeheartedly agree, but at the end of the day, we've got something going on. I think we've got a bill that generally puts the sideboards on that we need to ensure that people can continue exercising their First Amendment rights. I mean, the entire purpose of this being here is that political attacks, political lampooning, that's been around forever. But for years, all you have to do is see it was a cartoon or sees that someone wrote this on a flyer and distributed saying, person A said this to person B, and the person who reading it can immediately see, well, this is just on a flyer in my mailbox or a banner out of my Facebook, whereas we are encountering an entirely new capability to fully make the person think that that person is saying what they're saying, that actually happened. That's what we're talking about here. There's plenty of implications, but that is the core issue that we are focusing on here in this bill. I think we have a vehicle that, again, not perfect, sets forth a pretty reasonable sideboard on protecting people and ultimately protecting their rights while also ensuring that they are not infringed upon. With that, I call for the question.
Thank you, Mr. Co-Chairman. Yep, this is a very hard bill. I appreciate the really good debate on it, discussion on it. There's no question that there are rights in tension. And I do think that, I agree with Senator Northcott, we need to make sure that we get more eyes on this and have an opportunity for the legislature to hear it, debate it, and understand it better. With that, let's call the roll. It's a good choice. Roll call.
Mr. Chairman, this is a roll call vote for 24 LSO 236, unlawful dissemination of misleading synthetic media as amended. Senator Ellis. Senator Furphy. Senator Nethercott. Representative Andrew. Representative Singh.
No.
Representative Yin.
Aye.
Co-Chairman Western. Chairman Rothfuss. Mr. Chairman, we have 5 ayes, 2 noes, 1 excused.
Thank you. And with that, let's take a 10-minute break and come back to get on our next bill.
Thanks for indulging me.
Yeah. All right, let's resume. And next item on the agenda is going to be data privacy. And we'll look at data privacy government entities, Bill Draft 24 LSO 0107. Mr. Hopkinson, if you'll come up and walk us through the bill draft.
Thank you, Mr. Chairman. David Hopkinson with the Legislative Service Office, walking through 24 LSO 107, Working Draft 0.7, data privacy, government entities. Couple of things I wanted to highlight before we dive into this bill. It is structured a little unusually, as you'll see, with a number of effective dates, and I'll get into why that is. But the first section that we'll walk through, section 1, would apply immediately on enactment or signature. And then the next section would be delayed pursuant to those delayed effective dates. So keep that in mind as we're going through. But on page 2 of the bill, so this bill does go in and it creates 2 new articles, 921, or excuse me, 1 new article, 201. And it provides, in the first article there in 201, a number of definitions. A couple things I want to highlight in here. The first one is de-identified data, which gets into when personal data is not linkable to that person. So if it is cannot be reasonably inferred to an identifiable or linked to a natural person, then it would be de-identified data. Paragraph 2 provides for an identified or identifiable person, which is just someone, a natural person who can be readily identified by reference to an identifier such as a name, identification number, etc. The government entity, and this is a key definition, it means that the state and all its political subdivisions, agencies, instrumentalities, and institutions, and any local government entity. And essentially, it broadly applies across the board to state government entities, but does not include the judicial branch of government or any law enforcement agency in Wyoming. So as we see the term government entity throughout the bill, it does not include judicial branch or law enforcement. And our next definition, again, is key here because it specifies who is a law enforcement agency. And so a law enforcement agency, and this would mean that they would not have to comply with the provisions of this act, but that would be a county, municipal, college, or university police force, the Wyoming Highway Patrol, DCI, the Department of Corrections, or any state or local agency or political subdivision, or part of an agency or political subdivision, to the extent that their primary purpose is law enforcement. Now, at the bottom there, we have an exclusion. Law enforcement agency shall not include the office of any city, county, or district attorney, or other division of the Attorney General. And the intent there is that this law would not apply, say, to the district attorneys throughout the state, or the county attorneys in their prosecuting authority, or other divisions of the Attorney General other than DCI. Personal data is information that is linked or reasonably linkable to an identified or identifiable natural person, but it does not include de-identified data or publicly available information. Now, this publicly available information is defined in that same definition as information that is lawfully made available from federal, state, or local government records. You may note, and I believe there may be some testimony on how that definition differs from what is used in other states with respect to publicly available information. And the reason that that definition does not include some of the things that those other definitions might was simply because there was a policy question made in an effort to limit what data or what data sources the government may rely on for collecting that data. Moving on then to 202 on page 4. Subsection A provides that no government entity shall purchase, sell, trade, or transfer personal data without express consent, written consent, or except as otherwise expressly provided by law. Subsection B provides that any Wyoming resident may request a copy of their personal data from any government entity maintaining it. The government entity may charge a fee consistent with that in the Public Records Act. Subsection C provides that a Wyoming resident who objects to the accuracy, completeness, pertinence, timeliness, relevance, retention, dissemination, or denial of access to their own personal data that is maintained by a government entity, that they may file an objection, and within 30 days, that government entity investigates the validity of the objection, or if the objection is found to be meritorious after investigation, they may alter the contents of or the methods for holding or the dissemination or use of the personal data, or delete it, or grant access to it. If the objection is found to lack merit, they may provide the resident, or they shall provide the resident with the opportunity to have a statement reflecting the resident's views, maintained and disseminated with that personal data in question. And they shall notify the resident in writing of any decision regarding the defendant's objection. And subsection D is a bit of a catch-all. It provides that to the extent that a provision of this article conflicts with another provision of state or federal law, the other provision shall control. In other words, if there's a law that more specifically applicable to personal data, that law would apply. So that section 1 would be implemented immediately upon signature, or upon all acts necessary for us bill to become law. This other section has a delayed effective date. And 203 provides that in subsection 8, each government entity that collects or retains personal data shall adopt, enforce, and maintain a policy regarding that collection, access, retention, security that's consistent with all federal and state laws, and including this article. Subsection B provides that no government entity shall collect or maintain more personal data than reasonably necessary for the performance of their duties, that all personal data collected shall be necessary for a specific predefined purpose. Subsection C on page 7 provides that no government entity shall maintain personal data for longer than 3 years without an express written policy providing the justification for that extended period of time. And section 3 provides that not later than January 1st, 2025, the state chief information officer shall develop sample policies for use by state agencies, counties, cities, towns, and other political subdivisions, consistent with the requirements of this act. So this is a new in this version of the draft, but it has that extra requirement for the state chief information officer to provide those sample policies. Section 4 then would provide that not later than July 1st, 2025, each state agency would need to adopt those necessary policies consistent with this act. Section 5 would be July 1st, 2026. For each county, city, or town would then have to adopt those policies. Section 6 would be July 1st, 2027, that essentially every other political subdivision of the state. So by 2025, every state agency would need to have adopted policies. By 2026, counties, cities, and towns. And by 2027, everybody else. Section 7 is the effective date, which, as I kind of addressed earlier, provides for those various effective dates and on the requirements for having those policies adopted. One potential concern internally with this draft, it is fairly broadly applicable across a number of state entities, each with their own concerns, obligations, and things of that nature. And so there may be, one internal concern was just with that breadth, there may be some the potential for unintended consequences with the bill as drafted. But with that, I would stand for any questions.
Thank you, Mr. Hopkinson. Any questions for David? Go ahead, Representative Singh.
Thank you, Mr. Chairman. Mr. Hopkinson, on page 7, sections 3 through 6, can you just give us a little bit of an explanation for this timeline that we have written? Thank you.
Go ahead, Mr. Hopkinson.
Thank you, Mr. Chairman. Certainly, Representative, the reason for that, again, kind of a policy question for the committee, but the thinking behind that was to give the smaller entities that would have to apply to or that this would be applicable to, a little bit more time to come up with their own rules, whereas the state agencies who are more used to the rulemaking process, that they would be able to do that more quickly. And so that was the thinking behind it, having those successive periods of time, but certainly a policy question for the committee.
Thank you. Follow up?
Thank you, Mr. Chairman. And Mr. Hopkinson, can you just tell us who would have the most difficulties implementing this timescale specifically? Thank you.
Go ahead, David.
Thank you, Mr. Chairman. So during the working group, the discussion really was, that if you've got, a smaller political subdivision looking at things like irrigation districts, things like that may not have, special districts that may not have the manpower to really be coming up with their own rules. So there was some concern that maybe giving them a little bit more time would be beneficial. But that's kind of what that thinking was.
Thank you. Any follow-up? All right. Additional discussion? Mr. Pope. David?
Thank you, Mr. Chairman. So essentially, this was intended to capture any entity under the control of the state. So to the extent that those licensing boards are controlled by the state, then yes, this would be applicable.
Go ahead, Mr. Pope.
Thank you. That's understood then. And then, let's see, I believe it's on page 7, you give a 3-year time frame for maintaining the personal data with licensing boards. I mean, there's lots of data that's kept ongoing. Is that 3 years from last contact or 3 years in general? Just a question for administrative purposes.
Go ahead, David.
Thank you, Mr. Chairman. So in looking at page 7, subsection C, which I believe is what you're referencing, so that limit would be in place that they would have only 3 years to maintain that data. So if that data has been updated, I think that's a fair question. That, as far as when that timeline, that clock starts, I can see your concern there. Really, the bill comes down to if they want to extend that or have a greater time period, they can. They just need to have a policy in place. But that's a good question.
Go ahead, Mr. Pope.
Mr. Chairman, okay, my desire here is to make sure that like disciplinary actions and things like that carry beyond this 3-year period. And I don't know if that qualifies as personal data or issues like that. I am someone that believes that if someone in my position commits or has a disciplinary action, it should be on the record for a number of years, not just the 3 years. That may be a discussion for a different time, but that's my concern.
Mr. Pope, as drafted, all you would have to do is write that down as a policy, that for disciplinary actions, we will maintain personal data for 7 years, for example. You write that down, you have it as a policy, it's fine. You would just have to have it as a policy. There's no barrier to that other than the fact that you have to have something written down and some justification for it. You'll see providing a reasonable justification for the extended retention period based on what you provided. That's the intent, is that you don't just keep people's personal data because you're on a fishing expedition, you're curious, you don't like to throw things away, whatever the other reason is. If you have a cogent data retention policy, this doesn't limit it really in any way. And you could literally say, we're going to keep it forever, although you might have a hard time justifying keep it forever if somebody were to challenge that at some point. Does that make sense?
Yes, thank you, Mr. Chair.
Yeah, thank you, Mr. Pope. Additional questions? Additional questions? All right, seeing none, thank you, Mr. Hopkinson, appreciate it. We've got some, looks like we have ETS here. Mr. Sheehan, come on up. And both of you, yeah, please join. Thank you. Please introduce yourself to the committee and welcome.
Mr. Chairman, members of the committee, my name is T.R. Sheehan, the interim director at CIO for the state of Wyoming.
Proceed. Thank you.
Mr. Chairman, overall, I have no concerns with the bill. I do want to just provide some appreciation on the phased-in approach. I think larger agencies will have an easier time. Smaller state agencies, there could be some just initial challenges with in-house expertise to move forward. Representative Singh, to your comment on the timeline for local jurisdictions, I think they are resource tapped. They may not have the expertise or funding in place to move forward with that process. So allowing them the extra time to work through and implement this policy is a good measure. So I do appreciate the committee's consideration on the time on that. The comment I do have, it would be on, I think, page 4, section A, no government entity shall purchase, sell, trade, or transfer personal data. I would like to highlight there may be an instance where an agency might need to purchase data. An example I would offer is fraud, waste, and abuse. There may be a subscription service where an agency who has an entitlement system may want to do some verification on an individual, employment verification on an individual. So they may leverage a third-party entity to provide that information back. So that could be considered purchasing personal information. So I just offer that as a consideration for the committee. And then just mindfulness on the transfer personal data in the course of the state providing services to constituents. One or more agency may interact with each other. So just ensuring the provisions are in there that if an agency does work across agency in providing services to our constituents or businesses, that consideration's in there as well.
Thank you, Mr. Co-Chairman. Go ahead.
Thank you, Mr. Co-Chairman. So right there in line 12, going on to line 13, it says, as otherwise expressly provided by law. Are you aware of any other places in statute where it does allow these agencies you're talking about to purchase these subscription services?
Go ahead, Mr. Sheehan.
Mr. Chairman, Mr. Co-Chairman, off the top of my head, I am not aware, and that's why I bring that up. I'm just not intimately knowledgeable enough to say if that is currently in law or not, so I just bring that up as a reference point.
Thank you. Mr. Co-Chairman, any follow-up? So on the second point, the concept that maybe transferring personal data could be read as within the government, is that the concern?
Mr. Chairman, that's correct.
Okay.
An example I might give is, I'm trying to think through like voter registration. I know the Department of Transportation and the Secretary of State's office work hand in hand on that process. So that might be an example where information is shared between two agencies, so personal information is transferred. So again, I'm not sure if that's allowed by statute or not. but just being mindful that that does occur.
That's useful. And that the interesting point there is if it's happening but not authorized by statute, it kind of falls into an interesting gray area where we may or may not even want that to be done internally. Now, the case that you're providing might make sense, but one thing that does happen is bulk sharing of data internally, where we just hand over the entire database from one agency to another agency with zero barrier. I think ETS has actually been working on limited data sharing a little bit. I don't know what the state of that is, so that you're getting the right data and you have to have a request for that data. I think that program is still underway. But even that internal data transfer, the more places you have it replicated, the more vectors for data breach there are, and the less protection there is in place. So it's a good point to contemplate that internal transfer. Thank you for that.
Mr. Chairman?
Go ahead.
If I may add, where state agencies do data sharing, there's usually a data sharing agreement. And so we'll capture what data is being shared, why it's being shared, is there an expiration to it, what should happen when the agreement is terminated. And oftentimes from director to director, that data sharing agreement is renewed. So we do currently keep track of that to ensure that limited use of data is transferred.
Thank you. I think some of that came from the discussion years ago from the Digital Information Privacy Task Force of trying to have an internal policy along those lines. Did we put that in statute, or did that just become a policy?
Mr. Chairman, off the top of my head, I'm not aware. I'd have to double check that.
I don't remember either. Thank you. Senator Ellis.
Thank you, Mr. Chairman. I don't know that you're the right person to ask this question, but there are so few people in the room, and I don't know if anyone plans on testifying online, but examples I can think of are at the county level, when you buy a car and you go through that whole thing of going to the treasurer's office and then the other office and you walk back and forth. I'm just wondering, I'm guessing they share some data. I don't know if that's expressly authorized. I'm kind of sad we don't see counties here. And then the other one would be with unclaimed property. Every year we hear about, search up your name, see if you get some money. You'll be happy to know, committee members, I got 14 cents this year. And they sent me a check. It was awesome. Thank you. But other people, it's a little bit more money. And you can see, did it come from a telephone company or a wireless company that just couldn't find you? And then, the retention of that is for a family member, if their deceased loved ones are gone. Again, speaking from personal experience, how long that data is maintained on that website. You would hate for someone to say, oh, I didn't know Wyoming had unclaimed property. My mom passed 4 years ago. Now her data is no longer there, and I forego collecting the $50 that the state of Wyoming owed to her estate. So just all those little questions. I don't know if ETS is the right person to ask, but those were some thoughts I had.
Any thoughts on any of those?
Mr. Chairman, Senator Ellis, you are correct, not only within the counties, but from the county to the state. Right, when that vehicle is registered, for example, that information is transferred to the Department of Transportation and used for, among other things, law enforcement purposes. There are other systems where the county may have data that is shared with the state. Another example is the CAMA system of the Department of Revenue. So those do exist. And I would have to defer, as I don't know the statutory requirements between all of those systems off the top of my head. I'd have to do a review as well.
On the unclaimed property, that would fall into the same question that Mr. Pope had, which is unclaimed property has data retention policies, and they actually have internally, they do have an infinite data retention policy. They believe that they should never keep any of the unclaimed property as their policy. So it would be a matter simply of writing that down as the justification and keeping the data, but having a justification for keeping that data, which I think you've laid out perfectly. Further questions? Further questions? Seeing none, thank you. Appreciate your testimony.
Thank you.
Any additional public testimony in the room? Ms. Barco, come on up. And please, for the record, restate your name and welcome. The floor is yours.
Thank you, Mr. Chairman and members of the committee. I'm Ruthie Barco. I represent TechNet for the Central United States. We are here in an amend position on this bill. We have just a couple clarifying amendments, and by a couple, I literally mean two. So I will keep my comments brief. I'm here to reinforce the letter that we sent last night and answer any other questions. Our comments are in the context of the fact that 12 other states have advanced comprehensive state privacy bills. Those apply to private entities, but in the enactment of a plethora of legally defined terms, we wanted to opine that there was some alignment here that we thought would be prudent. In the enactment of those omnibus privacy bills, one of them, actually California was the first one, that the definition of publicly available information that's in this bill, the second clause was added that we have suggested, so that it says government records or widely distributed media or information that a person has a reasonable basis to believe has lawfully been made available to the public, so that it takes into account the full scope of what widely distributed media and public information in the public domain is. California added that post enactment because they were concerned that their law would be found invalidated in the courts on a First Amendment basis if that was not included. So we do think that that should be added. That's been added by every other state since in order to ensure that First Amendment protections are applied to private entities. And we believe that because this bill focuses on public entities, that it should be focused equally as well there to ensure that those First Amendment protections are applied in the government's use of personal data. Our second amendment is, and I think this echoes a little bit of the discussion with the agency's testimony before me, the prohibition on a government entity's purchase of personal data, we think actually provides a limitation of the government's provision of services rather than a benefit to consumers. To our knowledge and to what I've received from our members, most state departments of health purchase personal data in order to provide Medicaid services, to update their Medicaid rolls, to verify who's eligible, also to identify Medicaid fraud. So that's just one example that I have, but that was what we wanted to highlight to ensure that government services are not impacted by this. That is the last amendment that we have. We appreciate the opportunity to provide comment.
Thank you very much. Questions for Ms. Barco? And on the first point regarding the personally identifiable or personally available information, we actually did intentionally opt out of that second sentence because it is the state, not truly the public. The state acting as the state doesn't have First Amendment rights. We can restrict what the state does more than we can restrict what individuals do. And we were trying to limit, honestly, the state from trolling for data, for publicly available data that's easily found. If this were a bill to reflect individual rights, then that publicly available information would be necessary and restored.
Okay.
I hope that makes sense. So it was intentionally more restrictive because the state, individuals operating on behalf of the state, when they're on behalf of the state, can be restricted to whatever information we want. There's not a First Amendment issue with that. If we tell them, don't look at the internet, don't go trolling for information that's publicly available, no problem with that.
That's helpful to know the intent behind it. When legislative staff testified to that before, we weren't quite sure why that would be, but I will take that back as well. That's helpful to know if this is advanced.
Absolutely, and if we go down the path of CCPA or any of the other bills afterwards, which we've had some drafted and worked on, it would definitely be more in favor of those individual rights and an understanding of publicly available. So
it's helpful. Thank you.
Thank you. Appreciate your testimony. Any additional testimony in the room? I don't believe so. Seeing none. Testimony from Zoomland. Looks like we have Daza and Brendan. Anyone else?
That's correct, Mr. Chairman. We don't have anybody else.
Great. Let's bring in Daza. Daza, welcome back. Please introduce yourself and the floor is yours.
Thank you, Mr. Chairman. It's good to be back. My name is Daza Greenwood. I run civics.com, and I'm honored to have been a member of the working group that that helped to draft this bill. And my comments are very, very brief. I just want to speak in favor of the bill and to say, as a former state government attorney myself for the state of Massachusetts, and also a former local elected official, I've always felt that the public sector could do better in making sure citizens and others have good rights to our personal data. And I think this is a step in the right direction, and it's much more important now and going forward for people to have some modicum of additional control over personal data. And so I enthusiastically support the bill. Thank you.
Thank you, Mr. Greenwood. Any questions for Mr. Greenwood? Go ahead, Representative Ian.
Mr. Chairman, thank you, Mr. Greenwood, and maybe any other members of the working group that worked in the bill. Question on transferring between state agencies. Help me understand what the public benefit is for restricting transfer between state agencies, because I like to think generally of the state as a single entity. If we allow them to silo themselves off or require them to silo themselves off, what is the public benefit?
Mr. Greenwood, go ahead.
Thank you, Mr. Chairman. In general, the more personal data moves around, the more vulnerable it is and the harder it is to manage and to track and control. And so, I think, movement between entities, even when they're within the same broadly overarching membrane of a government, is still a kind of cross-entity movement. There are different systems and there are different processes, and so some tracking and controls are appropriate. I'm not in a position to speak to the merits of the current version of the restrictions in the bill and defer to others on that. But in general, in my experience, I'd say moving between big agencies is not that different from moving between different entities in practice.
Follow up, Mr. Minority Leader? No. Thank you, Mr. Greenwood. Any additional questions for Mr. Greenwood? Seeing none, thank you, Daza. Appreciate your testimony. Appreciate your involvement and participation in getting this legislation drafted. Thank you very much.
Thank you.
Mr. Marr. Welcome.
Wait,
Yours.
Thank you. Everybody can hear me and see me. Great. My name is Brendan Marr. I'm an MIT Media Laboratory alumnus. I was on the working group, the initial working group that looked towards porting over what was originally the California Data Privacy Act into something amenable to Wyoming for over a year or so. We worked through every line of that bill, trying to make it amenable to Wyoming, and we found it extraordinarily difficult. So that's the context I'm coming from. I will speak specifically to 3 words under Romanet 202C2, and the 3 words are grant access to it. Actually, that's 4, isn't it? And I have 2 questions for Mr. Hopkinson, and I would like to just follow it up with a short statement. The first question would be, Mr. Hopkinson, does this include agencies such as the Secretary of State and they're building out their integration, including UCC filings, et cetera?
Brendan, that was a little unclear. Can you restate that question?
Yes. So the question is, my understanding is this pertains to the Secretary of State's system that they're building out as well?
It would.
Okay, great. And the statement that I have and what I foresee as being a potential issue with the phrase grant access to it. And I want to say first off, I think it is very good phrasing as it is. Delete or grant access to it should not be changed. It works wonderfully. I do think that the term grant access to it will at some point need some further clarification, perhaps in a ruling, because, and this will come up, and it is coming up very shortly with the Secretary of State system and all the other systems that we're looking to integrate with digital ledger technologies, that when we have metadata, which is on a digital ledger, that metadata is not easily deletable. And that brings us to the second part of that clause, which is grant access to it, which is very good. However, agencies are going to need some clarity, maybe through ruling, on what it means to deny grant access to the metadata, which is referenced off of a blockchain, which can't be deleted. So, maybe it needs to be encrypted. There are other things that will need to be considered in regards to grant deleted to it, perhaps in a future ruling. Those are my comments. I hope they are helpful.
Thank you, Mr. Marr. I appreciate those comments. Any questions for Brendan? And I think to address that, it is a point we'll have to contemplate, alter the contents of it. There's a lot of flexibility of what can be done within those 30 days to try and remedy. That's basically the idea, is providing a remedy based on the objection, if the objection is found to have merit. In the circumstance that you're describing with the blockchain, obviously deleting would not be a remedy, but either altering the contents or providing access to the contents would probably be the appropriate remedy, depending on circumstance. So good points. Any further questions?
Thanks.
Seeing none, thank you, Brendan. Appreciate it. Yep, go ahead, Senator Ellis.
Mr. Chairman, is it missing a word? Wyoming resident who objects to the accuracy, completeness, pertinence may file an objection, maybe page 5, line 3, for the word may, just since we're here.
I see where you're at. Let me look.
It starts on the bottom of page 4,
Yeah.
paragraph C. Wyoming resident who objects may file an objection. We just think have the word may in there anywhere. We can continue, sorry.
No, Senator Ellis, I think you caught something here. I think we're gonna need a may. We've got a couple more minutes to contemplate that, but I'm penciling it in. And Mr. Hopkinson, do you have any thoughts on that? So page 5, line 3, insert may before file. I think
Mr.
that's
Chairman,
accurate.
There is a may on line 2 that I think
There it
would
is.
apply to the filing.
May, individually or through a duly authorized representative, file. There's our may. Yeah. It's a long enough sentence. It's like finding a needle in a haystack there. There's a may. And we have no further testimony, as I understand it? All right, testimony is closed. Back to the committee. Committee, what's your pleasure? We have a motion. Is there a second? We have a motion and a second. Any discussion before we go to amendments? We'll have a chance for discussion afterwards. All right. Seeing none, let's go to amendments. Any amendments on page 2? We're looking at definitions. Page 3. Page 4. So on page 4, I'll note that as A is structured, I think Representative Yin's concern about transferring data within the government is allowed, or excuse me, is not allowed unless you have some statutory authority to do that. This is something we discussed. It does lead to the question mark of the unintended consequences, and it's probably the key source of unintended or potential unintended consequences. Mr. Co-Chairman.
Thank you, Mr. Co-Chair. That's kind of going back to the question. I think my thought is if the committee is comfortable with it, we can leave it as written currently. And between now and session, we can verify if there is other language in law that allows them to engage in those practices. Because if it is, then the way it's written is fine. They can continue to do that. If there's not, then I think an amendment at some point during session to clarify that practice is acceptable will probably be needed.
And I'll note when we worked on this, there was discussion around the possibility of having something along the lines of, or by direct authorization of the governor. And that causes both solutions and problems. Mr. Minority Leader.
Mr. Chairman, thank you. I'll make a motion for an amendment here on line 11. After the word transfer, add to a non-governmental entity.
Second.
And so that motion would allow transfers between governmental entities. It would not allow transfers to non-governmental entities.
All right, we have a motion and a second, and let's double check that I'm understanding this correctly. There's two ways you could take it, but we have a definition. Government entity could mean any government, but we have a definition on page 2, Romanet 3, that government entity means the state and all its political subdivisions. And actually then excludes the judicial branch or any law enforcement, but you would have laws in place that would potentially allow that, where there'd be a warrant or subpoena. So I believe when read in its entirety, the motion, and I think this is what's intended, would be for transfers only within Wyoming state government, including all of its political subdivisions. Is that accurate, Representative?
Mr. Chairman, yes, and if it's friendly with the second, I would give leeway to LSO to make sure that conforms to the intent.
Okay, we have a motion and a second. Discussion? Mr. Co-Chairman.
Sorry, Mr. Co-Chairman, I apologize for being stubborn, but Mr. Hopkinson, are we aware of anywhere else in the statute that is expressly provides for agencies to engage in these practices?
Mr. Hopkinson?
Mr. Chairman, I could certainly come back with an answer, but at the moment, I don't have a good answer for that.
And for plain language, it may not be necessary, but you could add Wyoming a head of government entity just to be double clear on it, so that it would be no government entity shall purchase, sell, trade, or transfer except to another Wyoming government entity personal data without, that is actually, the Wyoming's redundant at that point, but it might be good redundant. Thoughts on that?
Mr. Chairman, I think the intent to make it clear makes it more confusing.
Fair. Okay. So we have a motion. The one concern I have with the motion is the idea that it basically would allow the Department of Health to effectively freely transfer any data it has to a weed and pest district in Campbell County, which is probably a bad thing. Now, there would be other laws that would govern, so that would limit what they could have, but personally identifiable information transferring from state agency to state agency or from state entity to state entity, if there isn't the intent in statute, is probably not a great thing. The unintended consequence concern, I think, is a fair concern, but the challenge is, rather than trying to find and identify circumstances where they don't have the statutory authorization to make a transfer and therefore complain and say, we're not allowed to transfer this data, shouldn't we be able to? Which would then lead to the potential for, all right, well, let's remedy that through statute or fine. We would just say, well, it's always okay. And transfers that are taking place when they probably shouldn't be, which then propagate and perpetuate personally identifiable information, sort of circumvents a lot of the intent of diminishing the amount of personally identifiable information. Go ahead.
Mr. Chairman, so I think on page 6, the 203 portion is enough protection to make sure that the data in between government entities isn't mishandled, because one, they'd have to have a public policy defining what kind of data that they are collecting, even if that is from another agency. And then two, it has to be within a specific predefined purpose on that subsection B. So I think that it's still reasonable to allow the transfers, given that they still are required to have a policy on what kind of data that they're collecting.
Thank you, Mr. Minority Leader. Any additional discussion or thoughts? Questions been called? No, go ahead, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. Representative, you might have to elaborate a little bit for me, but 203 on page 6 doesn't explicitly, it says that they can adopt the policy saying, well, part of our functions is to transfer data from agency A to agency B. But that doesn't necessarily, I think, address that concern that we're talking about in the amendment, and unless, of course, I might be not understanding properly. So if you could provide some clarification, that'd be great.
Mr. Minority Leader.
Mr. Chairman, in B, no government entity shall collect or maintain more personal data than is reasonably necessary for the performance of the government entity's lawful functions. And then all personal data collected and maintained by government entities shall be necessary for a specific predefined purpose. So their policy needs to say, Weed and Pest needs Department of Health's information for this specific reason. So if the specific reason is preventing fraud and abuse for whatever reason within the Weed and Pest, then maybe that makes sense for that transfer of data. But that the purpose still has to be defined, and that allows both the public and the legislature to say that purpose makes sense. I don't think blocking it and then requiring the districts or other entities to come before us and say, we need a statutory enactment for allowing this transfer is really the right way to go. I think the right way to go is to understand that transfers of data between government entities make sense, and we have these sideboards that say they have to define what they're using this data for.
Mr. Co-Chairman, and then Senator Ellis.
Thank you, Mr. Co-Chairman. I think that absolutely does make sense to me, because there could absolutely be a legitimate and necessary reason for that. And the other part that kind of jumps out at me in subsection A is without the express written consent. So in that scenario, another remedy, of course, could be that Department A could simply say when they interact with members of the public, saying, as part of these disclosure forms or terms and use forms that you have to sign, we're asking you for permission to share select information that we need to share with agency B as another potential remedy versus just giving them carte blanche, as the chairman said, saying, under any circumstances, under any conditions, we are okay with data sharing. So I think that's another option, a function that's in the bill that could potentially address that concern. It's more cumbersome, certainly, but I think it does address it.
Senator Ellis.
Thank you, Mr. Chairman. I just want to point out that your hypothetical may seem far-fetched until you think of mosquitoes and transmitting of diseases. And so maybe a weed and pest district does want some information from Department of Health. And I think they would have to articulate, maybe they don't need the social security number of the person who maybe's contracted malaria or name your disease, but that a case existed and maybe that alters their spraying functions, who knows? But I think those are the unintended consequences we're trying to, so I would agree, like the motion's a good one, and we're thinking it through.
Thank you, and I'm inclined to agree with the Minority Leader that the B paragraph on page 6, assuming that's well adhered to, should provide an appropriate check on the transfer from government entity to government entity. And maybe there's a way at some point we can strengthen that language at some point regarding transfer, but I don't have an idea for that now. Further discussion? Further discussion? On the amendment, seeing no further discussion, question's been called. All those in favor of Representative Yin's amendment, please say aye. Aye. Opposed, no. That motion has carried. Let's see, we are on page 4. Any further discussion on page 4? Any discussion or, amendments on page 5? We found our May. Seeing none. Any discussion on or amendments on page 6? Seeing none. Page 7. Seeing none. Is everyone okay with the way these effective dates go, where basically state agencies would be July 1, 2025, cities and counties, July 1, 2026, everything else, July 1, 2027? Seeing no amendments. Page 8. All right, discussion on the bill. We're on 24 LSO 107, data privacy government entities.
Mr. Chairman,
Mhm.
if I could, just for clarification, go back to the amendment and the intent. The way I am taking that amendment is to modify that subsection to allow for internal transfers of data, personal data amongst government entities. Is that?
Among Wyoming government entities, which is
Amongst
how it's
Wyoming government
defined.
entities. And I would also, just to clarify, that was intended to include the judiciary and law enforcement, even though those aren't government entities for the purposes of this bill.
That's a question I don't know. Representative Ian, what do you want on that?
Mr. Chairman, I don't think that's necessary to clarify because I think that there is already statutory authority for any transfers that law enforcement would require from the state.
Yeah, I think that's accurate. If they have a warrant or they have pretty clear directive under statute when they can get information. And if they don't have direction under statute, I'm not sure I want them to be getting information. So it's probably a good bright line as it is. Yeah. All right. Any further question on that? Mr. Hopkinson, you understand the intent there?
I do, Mr. Chairman.
All right. Discussion on the bill? Any thoughts? All right. Seeing none, roll call.
Mr. Chairman, this is a roll call vote for 24 LSO 107, data privacy government entities as amended. Senator Ellis? Senator Furphy? Senator Nethercott? Representative Andrew?
Aye.
Representative Singh?
Aye.
Representative Yin?
Aye.
Co-Chairman Western? Chairman Ruffus? Mr. Chairman, we have 7 ayes, 1 excused.
Thank you very much. All right. We are done with that bill. And at this point in time, we're going to go to committee directives, and then we'll get some open public comment, which I don't think we're going to have, but I'll offer it up in a moment. Mr. Hopkinson, anything you need from us at this point in time?
No, Mr. Chairman, I think things have been fairly clear. I guess I would note a number of those bills were tabled and remain to be discussed, but other than that.
Yep, so we have, I think, 3 that were going Division of Banking, if I'm not mistaken, and Title 13, and have to end up being personal. Senator Ellis, you weren't here for that. We have 3 bills, basically, that couldn't be sponsored because they deal with Title 13, so. Yesterday? Oh, you were, I'm sorry, you were here for that. Yes, you were. My apologies. Yeah.
What every girl wants to hear.
My apologies, Senator. So we'll have to figure out how to work through those and get the amendments that we talked about done and then look for sponsorship. Committee, anything else before we adjourn? I guess we have public comment, general public comment. Is there any general public comment in the room? Seeing none, general public comment on the internet. Excellent. All right, well, this was our last meeting. Thanks, everybody. Another great interim. Well done, good work, and we've got some bills that we've got to get through the session. So thanks, meeting adjourned.